Yeah, but the judge should,
Somebody is remotely moving.
like, if it's bad, our judge will just throw it out, so.
Yeah, so far so good.
Like, they don't usually just sign them if they are
Yeah, when
bad,
I do it, I read the notes before I
to see if they're bad. Yeah,
Because like sometimes I get them, they didn't even read it, and just like, no.
right, and the thing is, Judge Williams and Judge Orlando will see that, and they just won't sign them.
Yeah.
This is the only time I will type up is if I recommend somebody, because of the charges. We don't recommend, but the final decision is up to you. Misdemeanor charges, we don't recommend, but the final decision is up to you.
Okay, you didn't type in, so I
Oh,
went.
yeah, only type them in if it's out of state, unless it's in the state, as on trial.
I just hand it
Or
back
help
to
with
them.
them in that. We don't type it unless you ask us for the histories or something.
Pardon me?
You doing great.
What? What about?
On the monitor,
Oh,
juvenile. She's gonna continue to call.
well, he was moving everything, but I didn't move anything.
Oh, we were on adults.
Now you can continue to call.
No, it was, like I said, they remotely did something. I didn't touch anything. I promised. I did not touch anything. We weren't ready. You started moving everything. No, they still had stuff they had to finish, and I'm like, well, I just.
No, and then you'll say the name, and then someone will yell out which jail, and then you just post the appropriate jail, and you'll see the person.
Terrific.
It wasn't on the docket.
All those were?
It was not on the docket, because I
Good
was talking to her about it,
morning.
and she didn't know what it was from.
My name's, good morning.
Good morning, Your
My
Honor.
name's Andrea Ruth Gunderson. I will be the judge presiding today. You are here for first appearance hearing. There are three purposes for this hearing. One is for the court to determine probable cause for your arrest, which means whether there are reasonable grounds to believe that a crime has been committed. The second purpose is determine whether you should have a lawyer appointed to represent you. You have a right to counsel. If you have your own attorney and you want him or her present, you need to advise me and I'll direct the bailiff to attempt to reach him or her. Please understand the services of the public defender, if they're appointed, are not free. And if you eventually enter a plea of guilty or no contest, then a judgment may be entered against you for a reasonable value of the public defender's fees. And the third purpose is to determine what type of pretrial release, if any, should be set for your case. Each of you has the right to remain silent under the Fifth Amendment. You're not required to say anything, and anything you say may be used against you. Everything's being recorded. You have a right to communicate with counsel, friends, or family, and if necessary, you'll be provided reasonable means to do so. This is not your trial. This is not the hearing to determine your guilt or innocence, so please do not tell me the facts of your case. We may proceed. The first member? Okay. All right, is Sierra Shakis McCord?
Your Honor, if we could put this on recall, the women in Maine have been taken to the restroom.
Okay. All right, if that's all right, so that would include also Christina, Kelsey, and Barbara Lee?
They're coming right back, Your Honor. They're just not present right this moment.
Okay, so Piard, Lance,
President Maine, Your Honor.
okay. Mr. Ewance, you've been charged with aggravated battery and toucher strike battery.
This was like, make arguments regarding probable cause. In the probable cause affidavit, it says that, Mr. Yance grabbed the painting that fell off the wall. It seems like the painting was falling and the victim was struck on the left side. And I don't believe that there's any intent to commit, a battery. It
And-
seems like he grabbed a painting that was falling off the wall and the victim got struck in the face. It doesn't seem to have any intent, Your Honor, based on the probable cause affidavit.
Judge, just for the record, the state would respond that it states word for word, defendant grabbed a painting that fell off the wall and struck her on the left side of her face. Which, to me, is pretty obvious that he took the painting and hit her in the face with it. So, relatively low standard. I believe there's more than enough for probable cause.
Well, the phrasing in the probable cause affidavit is, for this court, a bit ambiguous. I will give the state 48 hours to perfect.
Okay.
Judge, in the meantime, are you setting the bond? Because right now it's no bond holding
Okay. Well, I'm giving the state 48 hours on count one.
Yes.
On count two, I am finding probable cause and setting a bond of $1,000.
The court signed off on the photo order.
State,
No objection.
so granted. the count one, the state has 48 hours to perfect, so I'm not finding probable cause. They have 48 hours.
Continuing the no bond hold for the
Pardon
next
me?
48 hour? Are we continuing the no bond hold for the next,
It's not a no bond, so automatically.
Right.
Once the bond makes it.
I mean, are we continuing the hold for magistrate for 48 more hours on the first count that Your Honor didn't find PC? Because right now he doesn't have a bond because it was hold for magistrate court.
When's
So,
magistrate court?
I mean, for today,
here.
so I don't know if you
Right.
want to continue that.
Magistrate, so Your Honor, technically, if you say hold 48 hours, they're gonna hold it like for a regular magistrate court. So technically, it's like a no bond, it will leave the bond down. So
For
you
two
can
days- for 2 days.
find no PC, still 48-hour perfection, or RR, or I put a reasonable bond, and then it's your decision. But technically-
Your Honor, what I would ask for is for Mr. Uance to be ROR'd on the first count if you're not finding PC, and then to hold him to the convenience bond of $1,000 on count 2. That gives the state 48 hours and really even more to perfect on count 1. If you're finding no PC on count 1, I'm asking for him to be ROR'd, not to be held no bond. It would be illegal for him to be held no bond if you're not finding PC on count 1, and it's not a punishable by life case. So I'm asking for him to be ROR'd on count 1, count 2 to be set at $1,000, and that gives state time to perfect.
Judge, however, it also states that the victim advised that the offender pushed her, intentionally touching and striking her against her will, which would be a battery. And the aggravated battery offender knew or should have known victim was pregnant. It states that he knew she was pregnant because he's the father of the baby. So even if you don't find that he hit her in the face with the painting, it states that he pushed her while she was attempting to see if her sister was okay, which is a battery aggravated by the fact that he is the father of her baby and she's pregnant.
Yeah, I believe that the push was against the sister and not the victim based on what the probable cause affidavit states.
It states that the victim advised the offender pushed her while she was attempting to see if her sister was okay.
Right, but I believe that person was not the victim. I
Nope.
believe that there's two victims in this case.
There's,
Okay, my understanding is Sylvia is the pregnant victim, and I believe that
I understand what you're saying.
So count 2 is as to the non-pregnant victim,
That's correct, that's my understanding, Your Honor.
right? So my ruling, so
okay.
I am going to do an ROR on 1 pending the 48-hour perfection on count 1, and finding probable cause on count 2 with $1,000 bond, and I'm ordering no contact with the victims.
Your Honor, just about the no contact order, if I can request, Mr. Uance has a child with the victim. I'm asking for third-party contact just so he can have visitation with his child, so that he can have a friend or a different family member contact the victim, just so he could see his child in the meantime.
State would be objecting.
That will be an issue that, when's his next court appearance, when's his first court appearance?
Only in Broward County.
Do we have an idea? A month? All right. I'm gonna order that there be third-party contact only to coordinate the time sharing with the minor child. The defendant is to have absolutely no contact of any kind with the victims. That is by social media, text message, and the third-party communication is only for the time sharing. Any further contact will be considered a violation of
Thank
the
you, Your Honor.
court's order.
And just so Your Honor knows, the female inmates are back in May.
Oh, okay, and then we can get back on track. All right, Sierra Shakis McCord.
President approaching, Your Honor.
What? Oh. Okay, Miss McCord. Good morning.
Hi, good morning. Morning.
You are charged with aggravated assault with a deadly weapon. I do. I do find probable cause. Ma'am, um, how long have you resided in Broward County?
Since 1998.
Okay. And are you currently working?
I am self-employed. I don't have a regular job, no.
Oh. Oh. And
Okay. I'm a graphic designer, Judge.
okay, state.
And I'm
Judge would be requesting $1,000 bond. I mean, state would be requesting $1,000 bond, I'm sorry.
Okay. All right. PD, do you have anything?
We
Okay.
do not object to the $1,000 bond, Your Honor.
All right, I'm ordering a $1,000 bond and no contact with the victim. Okay. All right, Christina Kelsey.
President Maine, Your Honor.
Okay. Ms. Kelsey, you are charged with touch or strike battery domestic violence.
And if I may be heard, like, probable cause?
Yes, please.
Your Honor, this looks like, at best, perhaps a mutual combat situation. Based on the probable cause affidavit, Ms. Kelsey was stated to have sustained injuries to the left side of her face, as well as several cuts and abrasions. The officer says in the report that she's unable to determine the primary aggressor. We would state, Your Honor, that there is no probable cause to hold Ms. Kelsey based on the charges she's charged with, the charge of battery.
State.
Judge, the state would argue that the issue of mutual combat is an issue for her judge, not for probable cause. Probable cause determination is only whether she touched and struck the victim against her will.
Okay. Court agrees that the issue of who was the aggressor is for the trial court to determine. I do find probable cause based on the probable cause affidavit. Ma'am, how long have you lived in Broward County?
all my life.
Okay, and are you presently working?
I am full-time.
Okay. And do you have,
I'm a cashier,
oh,
full-time cashier,
okay.
and I just,
State, do you have anything as far as priors or anything?
She has no priors in Broward County, Judge.
All right. All right, I'm going to release on ROR.
And Judge, the state would be requesting that the conditions of pretrial release be imposed and that she have no contact with the victim.
Yes, I'm gonna release ROR, and also, ma'am, you're to have no contact with the victim. That is by any means, direct contact, third-party contact, social media, text messaging, any of that. Okay.
I agree.
And Your Honor, I'm asking just Your Honor to sign an order so my office can take photographs of Mrs. Kelsey's injuries.
Yes, so ordered.
Thank you.
You are ordering pretrial on the record? You ordering pretrial?
And pretrial.
So she's not outright release, she's on pretrial, not pretrial?
She's on pretrial.
She needs to know to go to pretrial.
Okay, all right, ma'am. I'm ordering you to pretrial, so it's not outright release, it's pretrial. You'll check in with them, and you'll be notified as to what you need to do. Okay? Last time. All right. Okay. Barbara Lee Hausler?
North Broward, Your Honor.
Yes, ma'am.
Okay. Barbara Lee Hausler?
Yes, ma'am.
Good morning. Okay.
Good morning.
We are here to determine probable cause, and you are charged with a touch or strike and a battery and domestic violence.
Your Honor, this would be kind of the same situation. This is the other combatant. This is in relates to the last case, and it's between Kelsey.
Oh, this was the mother, Dawn?
Yes.
Correct.
And, again, the probable cause affidavit states that the inability to determine who the primary aggressor was. Ms. Hauser had minor injuries to the right side of her face with very minor swelling.
Left side.
Okay. I am finding probable cause. I am ordering pretrial and no contact with the victim, either direct or indirect, no social media, no text messaging, no email. And no contact order. Thank you. All right. All right, Robert Lee Mack.
President Maine, Your Honor.
Okay, Mr. Mack, you're charged with aggravated battery, causing bodily harm, and disability. Count 2, abuse of a child with great bodily harm, and number 3, touch or strike battery with domestic violence. I do find probable cause. State?
Yes, Judge, he has a prior declined assault and battery from 2004 and 2003, and a prior declined ag-bat pregnant female from 2011. The state, on the first count, the state would be requesting a $5,000 bond. On the second count, state will be requesting a $3,000 bond.
Yeah, if it's actually just asking this court to sign an order, taking Mr. Mack's photos, getting photographs of Mr. Mack's.
Okay, I have no problem with the defense doing it, with defense getting photos of the injuries. I am finding probable cause, and I'm ordering $5,000 on count 1, $3,000 on count bond on count 2, and
State will be requesting $1,000 on count 3.
$1,000 on count 3. I'm also ordering no contact with the victims.
Your Honor, if I may, for Mr. Mack, he's lived in Broward County for 5 years. He's self-employed. He is a pressure cleaner. He makes about $1,000 a month. He has friends and family that live down here that he can live with in the short term. But I'm asking for $2,500 on count one, $1,500 on count two, and the $500 on count three. Otherwise, Mr. Mack is going to be held on basically for him what's going to be a no hold bond because he cannot afford $9,000 in bond.
She posted. Count one was 1,000. Count two was 1,000. What is count two? What is count four? I mean, the one that she didn't put. That there was no failure to remain it.
So essentially, what you're asking is halving all of those. Is that your request?
Yes, Your Honor.
State would object, Judge, based on his history. I realize the cases were declined, but it appears that they are domestics.
They are domestic.
Yes. And especially the fact that a child was present and involved.
The bonds remain. Okay. Okay, we're concluded. The bonds remain.
Thank you, Your Honor.
As ordered. Okay, Furman Grisales? Grisales.
President Means.
Okay. All right, Mr. Grisales?
Yes, Your Honor.
Okay. You are charged with aggravated assault with deadly weapon, domestic violence, count two, aggravated battery with deadly weapon, count three, aggravated assault with intent to commit a felony, count four, touch or strike battery, domestic violence, and count five, possession of weapon or ammo by a convicted felon, and number six, tampering in misdemeanor proceedings. Yes.
In regards to count two, aggravated battery with deadly weapon, then in the probable cause affidavit doesn't state any battery that occurred. I believe that would be a requirement for the aggravated battery charge. There was no touching or striking in that place.
It's your position there was no touching or striking that took place? I'm reading that he then struck her in the face with a closed fist.
Sorry, there's no touching or striking with the deadly weapon.
Judge, in one of the, in the last paragraph, or the second to last paragraph on the last page, it states that he punched her in the face with a closed fist with a belt wrapped around his fist. Depending on which part of the belt it was, that could absolutely be argued as a deadly weapon.
And I would based on the probable cause affidavit, it doesn't state what part of the belt it was, and therefore, I don't believe that a belt can be used as a deadly weapon.
It's not on the docket.
Well,
In the manner that it was used.
well, I'm going to find probable cause in count 1, 3, 4, 5, and 6. I'm going to give the state 48 hours to perfect on count 2 as to the probable cause for ag bat.
Yes, Judge.
To identify what part of that belt was
Okay.
used. I am okay. State, do you have any recommendations regarding?
Yes, Judge. He has a battery and assault from 2015. All these cases are null pros. They're domestic sex bat, domestic strangulation, felony battery, and ag assault with a deadly weapon from 2015. Batteries in 2014, 2013, 2004, assault in 2005, and ag bat. So the state would be requesting on count 1 a $5,000 bond, on count 3 a $5,000 bond, on count 4 $3,000, and 5 and 6 $5,000 each. He has a lengthy history of domestic violence.
I would ask the court would entertain a planning of total order
I will sign the photo order. Sir, how long have you been a resident of the state of, in Brown County?
Your Honor, Mr. Grahalis, he was living with the victim, but he could stay with his dad. He could live with his dad in Cooper City. Mr. Grahalis has lived in Broward County for 29 and a half years. He works with his father. The two of them own an automotive repair and restoration business. Mr. Grahalis makes about $1,800 a month. I believe I heard my co-counsel ask for a photo order so we can take photographs of Mr. Grahalis' injury. I'm also requesting. Thank you. I'm also requesting third-party contact for Mr. Grahalis. Him and the alleged victim have a 13-month-old son, so I'm asking if a different family member or a friend can be the mediary between himself and the mother, just so he can have visitation with the son. I would also ask for the bond amounts that the state asked for to be reduced because Mr. Grahalis cannot afford that amount, making $1,800 a month.
All right.
I'm sorry, Joe. Where they have the, I have the, oh, okay.
Okay. I am ordering on count one. A $5,000 bond. On count three, a $1,000 bond. On count four, a $1,000 bond. On count five, $2,500 bond. And count six, a $1,000 bond. I'm also ordering a GPS and no weapons and no contact with the victim.
Judge, I'm sorry, could you repeat the bond for count 3 and 4? Was it one each? Okay, thank
One
you.
each.
Sorry. Thanks.
For count 2, is it RO for perfection, or you said in the bond?
On count two, it's ROR with 48 hours to perfect. I want a GPS and no contact and no weapons. Okay.
Thank you, Your Honor.
Thank you. Oh, also, I am permitting the third-party contact solely for the purposes of time sharing. Mr. Grahalis, please understand, you are not to have any contact with the victim of any kind, and that third-party contact is solely for the purpose of coordinating you having time with your child. Any other communication by that third party to the victim will be considered a violation, sir.
Understood, crystal clear, Your Honor. Thank you, Your Honor.
Okay, Levensky Asimi? Is he in Maine or is he someplace else?
It's just obvious. It just has to go to before his judge.
Might be out in the back.
Your Honor.
He's on page 10. It's in Maine.
Yeah.
Yes. Top of page 10.
Your Honor, if we could put that on recall.
Okay. All right, Clifford Anel Cadabel? Cadabel?
That's going to be North Broward, Your Honor.
That's North Broward. Okay. Clifford Anel Cadabel?
Yes, ma'am.
Okay. You have been charged with touch or strike, battery, domestic violence, and count 2, resist officer, obstruct without violence. I am finding probable cause. State?
Yes, Judge, he has declined throwing a deadly missile in 2016 and declined ag-bat pregnant female in 2015. On the first count, the state would be requesting $2,000. On the second count, the state would be requesting $1,000.
Mr. Cadillo is a lifelong resident of Broward County. He isn't working at this time, but he does have significant ties with the community. He stays with his mother and his father, doesn't have any kids. We would ask the court to consider a lower bound, perhaps 500 in count 1 and keep him around 100 in count 2.
Judge, the concern is that he punched the victim in the face to prevent her from speaking to the police.
Okay, well. I am going to, okay. I'm going to order $1,000 bond on count 1 and 500 on count 2. And no contact with the victim. And also a GPS. Okay, that concludes.
Your Honor, we have Mr. Wovensky Asame on top of page 10. He's back in Maine.
Oh, there we go. We're back. All right, Mr. Asame. All right.
Yeah.
You are. Oh,
Yeah, you want
okay. Okay, you have 2 capias out, so those will be dealt with, and before the trial judge on your other cases. There's 2 capias on case number 17-3104. So, and I believe
His judge is Judge McHugh.
and the bonds have already been set on that.
Correct, Your Honor. Do you have a date, Your Honor?
Do we have a date for? It's to be set in that division.
Okay.
All
Thank
right?
you.
Okay. Dante Elaine Davis.
President approaching in Maine, Your Honor.
Mr. Davis, you are charged with domestic battery by strangulation, dating relationship. I do find probable cause. State?
Judge, he has no priors in Broward. State will be requesting a $3,500 bond.
I'm sorry?
$3,500.
Okay. Mr. Davis, how long have you
Yes,
been
Your
a
Honor.
resident in Broward County?
Your Honor, Mr. Davis has lived in Broward County his whole life. He's 18 years old. He works at Panera Bread. He's a baker. He makes $11 an hour. He's currently a student at South Broward High School. He plays football there. He reports that he has scholarships offers to go to college starting this fall, that he's going to graduate South Broward High School. I believe the state asked for a $3,500 bond. I'm asking for a $1,000 bond just because he is a high school student and he's only making $10 an hour.
Okay, I'm ordering a $1,000 bond and no contact with the victim.
Thank you. Thank you, Your Honor.
All right. Kathleen Renee Hammett.
North Broward, Your Honor. She's going to be a medical reset, please.
Okay.
Thank you.
Sandy Ellen Green.
North Broward.
Okay. All right, Miss Green.
Yes, ma'am.
Okay. You are charged with creating a possession, use of a fictitious personal identification. I do find probable cause. State, I also on the probable cause affidavit noticed that the officer noted there were several active capias for her arrest, but I didn't see anything listed. Do you have any information?
I didn't see that either, Judge, but I saw the same thing in the PC affidavit. I'm going to look on Odyssey and see for cases there, because it looks like she has some cases of similar charges from 2015 and 2016, in Broward at least, that are still open and filed. So, just give me 1 second.
It's violation of probation. Violation of probation.
Okay.
Yeah, she did say that she had a violation of probation, but she's got bonds on those folks.
Judge, she has a warrant for violation of probation from 2016, and the case number is 1514667 CF10A. She's on probation. A warrant was filed for violation in October of last year. So she does have an active warrant.
She's in custody.
Oh, for this? Oh, okay. Thank you. I didn't know if that was addressed or not. That's probably why I don't have it in here. Thanks.
Okay, so is that the only, because the officer noted several?
That's the only one I see in this county.
It's 3 different cases on her.
We're here on count 5 only, so that's all we have to worry about today.
Okay, we don't have to worry about count 5. All right, I do find probable cause, and I'm gonna order a $1,000 bond. Okay, Laura Casper Leginos?
North Broward.
Oh, okay. There we go. Laura Casper Leginos?
Yes, ma'am.
Okay.
Commissioner.
Oh, do you want me to read the charges first, or you just want?
Rick. Michael Rick. See my brother, Mike.
Who's talking? Who am I hearing voices? Okay. Ma'am, you're being charged, you've been charged with count 1, possession of oxycodone, and count 2, trafficking in oxycodone. Okay, Counselor? Want to be heard on?
Yes, with regards to, count 2, says the reason any person normally bringing into the state 60 kilograms or more.
Okay, I'm sorry, you need to speak up, sir.
In regards to count two, Your
Yes.
Honor, the listed portion of the statute states that any person who knowingly brings into the state 60 kilograms or more of, and this lists several controlled substances, oxycodone being one of them. Your Honor, based on the probable cause affidavit, it seems like this is a situation where there was an undercover officer, and the undercover officer was the one who supplied the oxycodone, and that Ms. Longinos was simply attempting to purchase the oxycodone. So I believe that there's probable cause for the second charge of trafficking oxycodone.
State?
Just give me one moment, Judge, I'm sorry. Judge, a person who knowingly sells, purchases, manufactures, delivers, or brings into the state a person who knowingly sells, purchases, manufactures, delivers, or brings into the state actual or constructive possession, or who is in actual or constructive possession of 7 grams or more of oxycodone, is a first-degree felony, which shall be known as trafficking in oxycodone. So, selling, that includes selling, purchasing, manufacturing, delivering, and bringing into the state, not simply bringing into the state. And here in the PC affidavit, it states that she purchased it from the undercover officer.
I am finding probable cause on both counts. Ma'am, how long have you been a resident of Broward County?
My whole life.
Are you presently working?
No, I'm disabled.
Are you receiving disability?
I'm in a process. I had to reapply with a new disability attorney.
Okay.
My husband, who's there in court, is and my brother are there, right there.
Ms. Longinos says that she was diagnosed with neuropathy, fibromyalgia. I did have a chance to speak to her husband and her brother. They say that this causes like numbness and burning sensation.
Neuropathy.
Yes. Yes.
I'm allowed to speak, is it okay?
That's her brother.
She has, am I allowed to
Do you
speak?
really want them speaking at this point?
I would believe that this situation where this is an undercover officer, it wasn't like she was some trafficker or had some amount of oxycodone on her. I believe that the current bond is $250,000 on count 2, and she told me that the bond amount, considering her physical condition and her criminal history.
State, what's her back, what's her?
She has no history in Broward.
No history, all right.
In the
Well,
county.
Pardon me?
In the county.
Okay, all right, well, I am going to order 1,000 bond on count 1 and 10,000 bond on count 2.
Thank you, Your Honor.
Also, is this appropriate for drug court, to refer to drug court?
No, Judge.
All right, thank you,
Not based on the charges.
thank you. All right.
I'll let her judge, can certainly review that, but at this point, I would not recommend it for drug court.
Okay. All right, we have Brian LaQuince Webb. Is he there?
What was the name, Judge?
Webb, Brian Webb.
Present, Your Honor.
Okay, this appears to be a municipal city ordinance. Is the city attorney for that?
They don't come.
Not saying a word.
Your Honor, since it's a municipal ordinance, I can't represent him.
All right,
Just so you know.
then. There's also a VOP,
That I can.
Mr. Public Defender. There's also.
Yeah, I'm here. That I can represent him on.
Okay. All right. So, Mr. Webb, you're charged with municipal city ordinance violation. And then also a violation on probation for misdemeanor. State
Judge, for the violation of probation, the state would request that he be set in front of his judge.
that he what?
Be set in front of his regular judge. And a $25 bond on the ordinance violation.
Yes, that is for his judge on May 11th.
Okay, thank you.
Okay. All right. I do find probable cause. I'm going to set bond on the municipal ordinance violation at $25. And for the violation, you have a hearing set before your judge on May 11th at 10 a.m. And so that will be, your violation will be handled at that time.
Your Honor, I would just ask as a friend of the court, since the city of Fort Lauderdale is not present for the municipal ordinance, for Mr. Webb be held ROR on count 1, and for the violation, he has a date from what I see set for May 11th.
It is.
But just because the city's not there, I'd ask for an ROR.
Okay, I'll amend my bond ruling on 1 and just ROR on 1, but he's still gonna be in custody for the VOP and go before his trial judge on May 11th at 10 a.m.
Thank you, Your Honor.
Okay? Okay, Michael Ernest Smith?
I'm sorry, Judge, did you ROR Mr. Webb on the first count?
Count 1.
Okay, ROR, that's what I
Yeah,
thought,
ROR
thank
on
you.
count 1.
I'm sorry,
And
I
said
just-
that the VOP is
Yes.
still gonna be in custody for.
Thank you.
North Broward, Your Honor.
All right, thank you. All right, Mr. Smith,
Yes, ma'am.
good morning.
Good morning.
All right, it appears that you were picked up on capias on a misdemeanor. So,
Yes.
does he have a hearing date for going in front of the judge on his capias?
I'm not sure, Judge, if he has a date yet. I will check an Odyssey.
All right.
I went to court yesterday, Your Honor, for the open container. They gave me time served and a $208 fine on the open container.
That was yesterday?
Yes, ma'am.
He just, I don't see a new date in Odyssey. Do you, Madam Clerk?
It's probably, other count, right now, we're here on count 3 only, so maybe it was 32,
I don't see a date for count 3, I mean.
Right.
Pardon me?
3 only.
I know we're hearing the capias on count 3, but I'm curious then, was yesterday's hearing possibly from the capias that was taken care of from the hearings on count 1 and 2 yesterday and it just got lost in the translation?
Well, his other case was, adjudication of what held, that was yesterday.
Right, he said he was before the court yesterday and that appears to have been played out.
What was that case number yesterday?
17001420 memo 40.
Okay, and the capias is on 164820 MM 40A.
And it was just that one case yesterday? So right now, we're here on another case today.
There's a different outstanding.
Yeah,
Okay.
'cause 48, they don't take them to that, they came into custody the same day as they did, oh, no, that long.
All right. State?
Judge, the state would request that he be seen before his judge on this case number.
When's he set to be seen?
He's not set right now. He needs a date from this court, right? Correct?
Right, well, no, not from this court, he used to be brought the second look first because this is a satellite case.
Okay.
So, that's what happens, there's a process. But if you clear it out today, I don't know if anything else is gonna come up, but you'll be time served on this case as well. This is the only thing holding it. But if he's not
He
involved, so we'll be-
That's what I'd like to, what's the underlying charge that
On
he's
this
pleading to?
16 case,
Yes.
trespass. KPS misdemeanors for trespass. 16 4820 MM 40A.
And there's nothing else pending. What's his history?
That we don't know.
Another count domestic violence.
Oh.
Pending?
Yeah.
Okay, okay. So this KPS is for the trespass?
Correct. It's for misdemeanor trespass.
All right. No?
He might have went through first.
I mean, if that's it, yeah, all right, all right. All right. I am ordering a $500 bond, and then you'll deal with the KPS before your trial judge when you go back when that date is set, sir. Okay?
Yes, ma'am.
All right.
Thank you. Thank you, Your Honor.
Let's see if the main. Kiara Monet Henderson?
President Maine, Your Honor, she refused the services of the public defender.
All right then. Good morning, ma'am.
Good
Do
morning.
you have private counsel?
No.
Okay. And you've refused the services of public defender. You've been charged with abuse of a child without great bodily harm. All right. It appears, ma'am, that there is an active warrant, that this is how you were picked up. Actually, you walked in and I guess
Yes.
voluntarily surrendered on an active
Yes.
warrant.
Yes, because that day, my child's advocate called me and told me I had a warrant. I didn't know I had one, because I went to court in February and I didn't know.
Okay, ma'am. State?
Judge, are you finding PC for the?
I'm actually very involved in my kid's life. Like, I just
Okay,
seen them
ma'am.
this week.
Ma'am, this is not your trial. You don't talk about the facts of your case with me, because anything you say can and will be used against you. You have Fifth Amendment rights right now. You don't want to be discussing this with me. That's the facts of the case you want to be discussing with your attorney. You can deal with those issues for the trial court. This hearing is only to determine probable cause on the charges and, if appropriate, a bond. I am finding probable cause.
She has no Broward priors. The state will be requesting a $2,500 bond.
Okay.
Your Honor, can I object to that?
Object to what, ma'am? The bond?
Yes, can it be lower than that?
Well, ma'am, how long have you lived in Broward County?
14 years, and I'm
Okay,
currently full-time in school.
And other than your child, do you have any other family in Broward County?
Yes.
Okay, and, do you have a job? Do you
I'm
have
a
a job,
full-time
ma'am?
student. I'm a full-time student because I aged out of foster care in Florida. So I get like a check every month to pay my bills and stuff like that. I have my own place, and I go to school full time.
Okay. All right, I'm gonna order a $1,000 bond. And right now, there's a pending, from what you're saying, there's a pending dependency case?
Yes, actually, next Thursday is it's for reunification for next Thursday.
You have reunification next Thursday?
Yes, Your Honor.
All right,
Yes, Your
well,
Honor.
I'm ordering that you have no contact with the victim in this case, until such time as your trial court makes further determination, okay?
Yes, Your Honor.
All right. All right, next case. All right, Marlene Claudia Izquierdo.
North Broward, Your Honor, we were informed that she's bonded.
Oh, she has bonded, okay. No, 1,000. What? 1,000, no contact.
Until her judge.
Until the trial court judge. Okay. All right, Samantha Lee, Mavika Tracy.
North Broward.
North Broward?
Sure, yeah.
All right.
Yeah. Yes, ma'am.
Okay, Miss Mavika Tracy?
Yeah, you can call me Miss Mavica. That's fine.
Miss Mavika, okay.
Uh-huh.
You are charged with grand theft auto, false ID given to a Leo, and also there's a probation violation.
Yes, ma'am. Now the
Okay,
Grand Theft Auto.
Ma'am?
I'm not. I'm. Yes, ma'am.
Okay, this is a probable cause hearing. This is not your trial. This is not to determine guilt or innocence. You
Okay.
don't discuss the facts of your case with me because you have Fifth Amendment rights. Anything you say can and will be used against you. You need to discuss any of the facts of this case with your attorney. Okay?
Okay. Uh-huh.
All right. So, I am finding probable cause. Stay.
Judge, she has no priors in Broward. She is on probation or community control in Palm Beach County, which is count 3, the violation.
Oh.
Looks like a VOP.
Pardon me?
Looks like a violation of probation.
Right.
In Palm Beach County. So for that case, she needs to go before her Palm Beach County judge.
Okay, so we basically will, like, hold her for that, notify them?
Yes.
Okay, so.
But on the other 2 counts, state would be requesting $1,000 on the GTA and $100 on the false ID.
Okay.
Just requested, I know there's $1,000 bond right now in the first count and, 0 on the second count. We just asked before the bonds where they are, she's being held no longer.
Okay. All right, I'm gonna order 1,000 on, a bond on count 1. No bond on count 2 because she is as stated. Pardon me?
No bond required, you're not.
No bond required, I'm not saying.
0.
No bond required on count 2, and because right now she's got a hold for Palm Beach County.
Thank you, Judge.
Finished?
Yes.
Thank you.
Thank you. All right. Is Adriana Bianca over in Maine? You'll say. All right, see, just after I popped over. Adriana Bianca Dimitri?
Yes, ma'am. Yes.
Good morning, ma'am. You are charged with grand theft. Okay, ma'am, I am finding probable cause. State?
Judge, she has no priors in Broward. State will be requesting $1,000 bond.
Ma'am, how long have you lived in Broward
Yes.
County?
In
How long have
6
you?
months.
6 months. Do you have any relatives or ties to the community right now?
Excuse me? I don't understand.
Okay, do you have any family in Broward County?
Your
Yeah,
Honor.
my husband.
Okay,
My
hang on a
husband wants.
second. Do you need a translator, ma'am?
I understand, ma'am. I understand.
Oh, okay.
My husband is here in Hollywood. He lives in Hollywood.
Okay, so do you have a job?
My husband, yes. I don't have. I don't have a job.
Okay. All right. I'm ordering a $500 bond. Okay. Can this do pre-trial or no? With
She informed pretrial that she.
Pardon me?
Is gonna post a bond. She informed pretrial that her husband was gonna post a bond.
her husband what?
Is gonna
Gonna
post.
post.
Okay. All right. Can she do? Can we order pre?
You can.
Okay, then order pre-trial as well.
Her own pretrial?
Yes, pre-trial.
Without a bond or with a bond? Without?
It's up to, it's the Honor's discretion, because we stepped back because the husband said he's gonna post a bond, but it's up to the Honor's discretion if she wants to put a pretrial with a bond.
Pre-trial with the bond. I ordered 500.
Okay.
Yeah, 500. All right.
Okay. Yeah.
That's concluded. Is Melissa Martinson at North or Maine?
North Broward.
Oh, good. So Melissa Lauren Martinson. There we go.
Hi.
Good morning, ma'am. You are charged with possession of. All right, I'm just gonna call it Xanax because I can't figure out the other. And possession of cannabis of 20 grams or less.
Correct.
Judge, I'm sorry, what page is she on?
Yes, 7.
I don't see her. Oh, I don't know why I don't have it.
All right. Yeah. Okay. Okay. I am finding probable cause. Okay, so I proceed. As count 2, you're arguing probable cause, or count 1? Okay, on the cannabis. Oh, all right. So your argument as far as probable cause on count 2 is that the PC affidavit doesn't state it was tested?
Yeah, there was no field test, confirming the substance.
Okay.
State's position is that the officers don't need to field test the drugs for probable cause. Based on their training and experience, they can determine whether there's probable cause to arrest for cannabis. Drugs don't need to be field tested. It's not required.
I mean, if it's not field tested, there are field testing procedures. How would we know whether the substance is actually what it's supposed to be?
Based on the officer's training and experience.
Correct.
And the recognized odor of and his identification of. It's a little different than unmarked white pills. It's a little bit more clearly identifiable by an experienced and trained officer than. So I'm gonna find probable cause on both counts. I'm going to, order, okay, hang on a sec. Ma'am, how long have you been a resident of the state, of Broward County?
I'm not.
You're not a resident?
I live in Boca.
You live in Boca. Okay. And are you employed?
Yes.
What do you do?
I work at Palm Beach Puppies.
Okay. All right. I'm gonna order pretrial and refer this case to drug court. State?
It's a felony, correct? I don't have the packet in front of me. That's the one I'm missing. I don't have any paperwork either.
Pardon me?
Oh, then probably not for drug court, Judge.
She did decline pretrial. She said she prefers the bond, but it's up to your.
All right, then I'm gonna order $1,000 bond on count 1 and all right, so just $1,000 bond on count 1 and no bond required on count 2.
I apologize, Judge. I apologize. That one must have gotten lost in the shuffle. Paperwork.
Hang on just a second. Okay, well, I still don't know how to make this work again. Ah, there we go. All right, dang. Okay. Robert Lee Cyrus.
President Maine, Your Honor.
Okay, terrific. Okay, Mr. Cyrus, it appears you were picked up on 2 capiases that already have bond set. state, is that
That's
correct?
that's what I have, Judge.
2 capuses.
Yes.
With the status scheduled for May 11th at 10 o'clock.
Okay.
Your Honor, Mr. Cyrus is interested in resolving the case today if Your Honor can make an offer, if you're willing.
I can look at his history, Judge. He has a lengthy history. So it's up to Your Honor if you would like to resolve it today. Going back to 1994.
What are the pending charges?
He doesn't have any pending charges. They're all closed. He
No,
has.
but the capious, what he wants
the
to plead
capious.
to.
I'm sorry. I thought you
It
meant.
has to be something that he
Yes,
wants
I
to-
thought you meant his priors.
No, I'm talking about presently what
a
he wants to
trespass
plead to.
and an open container.
And okay, state, do you have any position on?
No, Judge, he was released from prison in 2013, and this is his first charge in Broward since then. No, that's incorrect. He has another pending open possession of cocaine from February of this year.
Okay, okay, he's got another open pending charge, for drugs, so,
Felony.
no, I'm not.
I understand, Your Honor.
Okay, so.
Thank you.
Yeah, your bonds have already been set in the K pieces, so you'll just go before your trial judge on May 11th at 10 a.m. and you can address all your issues then and see what your trial judge wants to do. All right. Thank you.
Thank you, Judge.
All right. Bobby Bronson Stanville.
President Maine, Your Honor, this is a municipal ordinance.
All right. And it's the weekend, so the county attorney isn't here.
Sometimes they're here and sometimes.
I know, but right now.
Right, no county attorney.
They aren't here unless they arrive later. They weren't here earlier. Okay, so, it's not your purview, state, to have anything. This is them, right?
I'm sorry?
It's not your purview because it is theirs.
But I will tell you that he has no priors in Broward.
All righty then. All right. Sir?
Yeah.
Good morning. All right.
Tell them when you get up.
How long have you been living in Broward County, sir?
6 years.
Okay. Anybody have a public defender? Anybody have a position on this one? All right. So.
Ask for ROR.
Okay.
What does that mean?
Police are overcognizant, sir.
I have no objection to that, Judge.
He's kind of giving you crip notes on this. So he has no priors at all?
Not in Broward. No, I have no objection to that.
Okay. All right. I'm going to dismiss the charges.
Oh, okay.
All right,
To Your
sir.
Honor's discretion.
The county attorney's not here. It was essentially. So I'm dismissing the charges.
Okay, great.
All right, so they'll process you out and release you. Have a good day. I found PC, but I'm dismissing.
You got no business.
All right, Steve Dorival.
President Maine, Your Honor.
Okay, Mr. Dorival. You are charged with driving with a suspended license, altered license plate, expired motor vehicle registration, driver present non-current proof of insurance, and then there are 3 outstanding capiases for traffic. On count 4, driver present non-current proof of insurance, okay?
Probable cause affidavit states that he was issued a citation for vehicle not insured, but there's nowhere else in the probable cause affidavit that says he actually didn't have any insurance. So just the issuing the citation alone, I don't believe it shows probable cause that he didn't have insurance.
State?
Judge, I think that that's enough for PC, that officers wouldn't have listed in their PC that they issued him a citation for no insurance if he had insurance. There's, the citation's attached, no proof of insurance, operating not properly insured, proof of insurance required.
Yeah, my argument would be that if he was issued a citation for driving without license, but there was nowhere else in the probable cause affidavit that stated that the license before was checked and had it, then that wouldn't be probable cause for that charge. So there's nowhere else listed aside from the issue citation saying that he actually checked and saw that this person had no insurance.
And Your Honor, I would add, I can't hear everything going on, but on the second page of the PC, the third to last line, the officer says he was cited and issued a citation for driving without. I don't have copies of the citation. I don't know if my
It says
counsel
driving without a license with knowledge. Actually driving with a suspended license, I think, with knowledge. Vehicle not insured, expired tag, and altered tag.
And I have copies of all those citations, Judge.
Okay.
All the citations, Judge.
State has a copy of all the citations.
Okay. I just don't have it here.
So I'm finding probable cause for count 1, 2, 3, and 4. Now, as to the capiases, the bond's already been set, so I'm not requiring additional bond on the outstanding charges. He'll go before, because he's held on the capiases, so he'll have a status hearing scheduled on May 11th at 10 a.m. He'll go before his trial judge, and they can address the issues then.
Thank you, Your Honor. I'm just asking for an order for him to access his phone. He has family that he wants to get in touch with. I'm just asking for him to access his property so he can get those phone numbers.
Okay, I'll enter an order that he can access his property, get his phone.
Thank you.
Okay. Adolphus Albert Wilson?
President Maine, Your Honor.
Okay. Mr. Wilson, you're charged with petty theft, and first-degree property, and false ID given to a law enforcement officer. Okay, I am finding probable cause. State?
Yes.
It appears on count 2, the false ID given to the Leo.
Yes.
On page 2 states that the reason was that Mr. Wilson told the officer his name was Adolphus Wilson with a DOB. and that was a lie according to his criminal history, that his real name is Frederick Wilson Jr. But the charges are on the alias. State?
That is correct, Judge, but on my booking report, I do have a number of aliases here, all with the last name, and one includes Frederick Wilson.
Oh, I understand.
I know.
The issue is to find probable cause on a fake name.
And Judge, if you'd like, I can take 48 hours to review, and I can speak to the officers and have them put the correct name on the PC affidavit, because I agree with Your Honor. The real name is listed under defendant name, and the real name is listed under alias, and the false name is listed under
That's
defendant
where
name.
the problem
It should be
is.
switched.
I can't find probable
Correct.
cause on, I'm gonna give you 48 hours
Okay.
to perfect and correct this.
For both counts, correct?
For both counts, because you're charging him under an alias.
Right.
That's on both counts, to perfect. So,
Okay, thank you.
all right?
So just so I'm clear, Your Honor, he's going to be ROR'd on both counts, and then the state has time to perfect it if they choose to?
Well, state.
Because otherwise,
I'll leave that up to Your Honor. I mean,
Your Honor, I would
Judge,
say he's not held
it's-
for 48 hours on a no bond
Right.
hold on a petty theft.
And it's 2 misdemeanors, so because it's a misdemeanor, they're both misdemeanors and one's a petty theft. I don't think he should be held no bond for those 2 charges in the meantime.
Right. Okay. So,
So he could be,
you can be released.
and then
An
I'll
ROR,
make a
and
note.
they have 48 hours to perfect.
And he has to come back for the 48 hours, though.
You have to come back, sir, for the 48-hour check. Okay?
Okay. Okay.
But we're gonna ROR
Thank
you
you.
right now, but please show up, sir.
Oh, I will. It's going to be room 235 in the main courthouse, correct, Your Honor? Just
Pardon me?
All in the
so I
morning.
could.
Okay, thanks.
He's going to come to the magistrate court Monday morning where you are, in room 235,
Yes,
correct?
yes, we'll still be in 235 for another week. What?
For perfections, he don't have to.
Oh, okay.
Oh.
I'll write it in the book.
Thank you.
Oh,
Sorry,
okay.
for the kids, they have to come back, that's why I asked.
Sorry about that.
So
No,
I get,
sir, yeah,
sorry.
it'll just be the public defender that'll deal with this. You don't have to appear, sir. The 48 hours public defender will make sure whether they've perfected or not, sir.
I'm sorry, I'm used to the kids, so I.
Okay. We're all working through this.
Thank you.
Have a good
Thank
day.
you, Your Honor. All right.
All right. Hold on. All right. Richard John Wilson? Okay, different person.
Good morning.
Good morning, Mr. Wilson. You are charged with trespass property, not a structure or conveyance.
Yeah, I was just trying to enjoy the air show at Fort Lauderdale Beach.
Sir, don't, did you hear the original statement I said at the beginning of don't give me the facts?
Oh, yes,
of
I
your
did.
case? Okay?
I apologize.
All right, not a problem. I just want to make sure that you understood. I don't want to hear the facts of your case now. It doesn't serve you to do that, all right? So, let me see. Okay. I am finding probable cause state.
Judge, he has a lengthy history going back to 2011. Looks like they're all misdemeanors, but it's multiple cases in 11, multiple in 12, 13.
They're all stemming from homelessness, ma'am. I'm a homeless man. And I have no family.
All right.
We're in Massachusetts.
State would be requesting $100 bond.
I can't afford it, ma'am. I have no money. Is it possible you'd be willing to consider an ROR? I'd like to be out for Mother's Day.
Okay, so you said you're homeless, and so.
Right? I'm currently residing at the BOC, and I don't want to lose my bed.
Okay, so you do have a bed. You do have a bed at BOC.
Yes, I have a BOC. I have a bed at the BOC, but I would need to be ROR'd to keep that bed.
All right. Then this court wants to make sure you have a bed, but we also want to make sure you come back. So I'm going to ROR.
Yes, I promise.
I'm going to ROR you. All right, I do find probable cause. I'm going to ROR you, and you'll be back to make sure that
Yes, ma'am.
you process what you need.
Happy Mother's Day, by the way.
Okay. Hold on just a minute. Let me. Okay. Let me just. All right. Do you have the address for BOC?
1700 Blunt Road, ma'am.
Okay, hang on.
And I'll make sure I have my coordinator call the courts when I get there.
All right, well, give us the address, 1700.
Blunt Road, ma'am. BOC. Right next to St. Lawrence. Blunt Road. Like a blunt.
Do you have a zip
Blunt
code?
Road.
Do you have a?
Huh?
Do you have a zip code there?
I believe it's, what is it?
33069.
33069.
All right, sir. I would recommend you not say anything further. Have a good day. You've been ROR. Yeah, have your coordinator contact. Make sure you show up. All right, you're ROR, sir.
Thank you.
Have a good day.
Thank you, ma'am.
Melvin A. Figueroa.
President Maine, Your Honor.
Figueroa. Thank you.
President, Your Honor.
Good morning. All right. You are charged, sir, with driving while license suspended, and you also have a current capias for another case, a traffic misdemeanor. All right, I am finding probable cause on count 1, and I'm going to order a $100 bond on that, and there is a current capias out that already has a bond set. State, do you have anything else to add?
No, Judge.
All right.
Your Honor, I would just request that you sign an order allowing Mr. Figueroa to access his property so he can get his phone, so he can call his family to let them know where he is, and so he can bond out.
All right, so ordered.
Thank you.
Thank you.
Rodrigo Mendez.
He bonded, Your Honor.
He bonded. Dontrell Raven Williams.
President Maine, Your Honor.
Okay. Mr. Williams, you're charged with driving while license suspended without knowledge, and you also have a capias for traffic in another case. Okay, I do find probable cause on the driving while license suspended without knowledge. Since you already have a capias with a bond already set for that, I'm not requiring any additional bond on the DWLS. Anything further you have to add, Mr. Public Defender?
No argument, Your Honor.
All right.
Thank you.
Thank you. What is the public defender's name over there, so I don't have to call him Ms. Johnson?
Dressler, Brian Dressler.
Dressler?
I thought it was Dessler.
Sorry, Your Honor?
That's okay, rather than calling you Mr. Counselor, I just wanted to know what your last name was.
Dessler, D-E-S-S-L-E-R,
Yeah, we got
Your
that
Honor.
straightened out over here, thank you.
Oh, okay, thank you.
Okay, Joseph Ronald Shea.
President Maine, Your Honor.
Hi. Mr. Shea.
Hi.
Hi. You're
Hey,
presently
that's
charged
all, y'all
with DUI, improper change of lanes, unlawful speed posted, and failure to obey, to display vehicle registration. Okay.
Relates to count 4, there's no mention in the probable cause affidavit of failure to display vehicle registration.
State?
Judge, I don't have any information regarding that either. I don't have a citation attached.
Okay, well, it's not in here, so, I mean, I can give you 48 hours to perfect that, but it's
Yeah, I
not
don't
really
think
gonna make
it
a
would
massive
change.
difference in things, so I'm gonna, I find no probable cause in count 4.
Yes, Judge.
All right, I am. All right, so I'm gonna order $1,000. Oh, state, is there any prior?
Judge, not in Broward County, but I know this is DUI second offense, so it must be from a different county or state.
All right.
But I have nothing in Broward.
Okay.
See, in a DUI in South Dakota, Your Honor,
Oh.
in 1992.
Oh, thank you.
Does that make it 3, or is that this?
That's-
Is that the
That's the
first?
first one.
Okay, yeah, that's why we had it as a second offense. Okay. Mr. Shea,
Yeah.
how long have you been living in Broward County?
09.
Since 09.
2009.
Do you have a job?
Yeah. 2 jobs.
Okay, great. And, all right, I'm going to order a $1,000 bond on count 1. And no bond required on 2 and 3.
Thank you, Your Honor.
Well, 4.
Oh.
4, they have to perfect. So I didn't find probable cause on that.
Oh, we're not.
Not for magistrate, see, on the end slash.
Yeah.
So,
Oh, so I don't have to even address it. Thank you very much. All right. We're done. Buddy Everett Johnson.
Bonded, Your Honor.
All right. Primitivo Garcia.
Brief recall, Your Honor. He stepped out. He's not currently in here.
Okay. I don't know. Okay. McQueen Shakeen Smith.
Recall also, Your Honor.
Malik Biename.
Present, Your Honor. He refused the services of the public defender.
All right. Mr. May, you're presently charged with premeditated murder in count 1, aggravated battery with deadly weapon in count 2, And aggravated assault with deadly weapon in count 3. State.
Yes, Judge, the state
Know
would
what I'm
be,
about to ask on count 1.
the state would be requesting that the defendant be held without bond. This is a punishable by life felony. There was a warrant that was signed on the 2nd of May. I can look it up and see which judge it was. I can't tell by the signature. But the state would argue that that's enough proof evident presumption great for the defendant to be held no bond in this punishable by life felony. And count 1.
I don't have the PC for count 1.
Judge, it was a warrant. It was already signed.
Okay, so
it's
already
been
present
correct.
case.
It's just the
Alright.
issue of bond. I have a copy of the affidavit for the arrest warrant, but I also have a copy of the warrant after it was signed. So that's already been determined.
All right.
It's just
Well-
the issue of bond. It says that the affidavit says the round from the gun narrowly missed the victim's head. It's an attempted.
Okay, here's my question. Is the warrant for attempted or is the warrant?
It's attempted. Attempted premeditated murder.
Well, the count here says premeditated murder, not attempted premeditated.
On the booking report?
I'm looking at the
yet.
I'm looking at the findings in order that you want me to sign. It says premeditated murder, and I didn't see that there was any.
I'm sorry, Judge. I'm not sure which page you're looking at.
Top page.
Thank you.
The order I'm supposed to sign, put my name to. Count 1. It says premeditated murder. No attempted.
It's like a subsection of the statute. So if we find for attempt, what I do is I write.
I didn't even shoot
Okay, well,
nobody.
since I wasn't it's just the warrant that you want me to find PC based on the warrant.
But it's already been found.
It's already been found.
By the other judge who signed the
Alright,
warrant, that there was
but-
enough to arrest him, probable cause to arrest for the charges in the warrant.
All right. Well,
And the
they-
charges in the warrant, just for the record, to make sure we're on the same page, are attempted murder, aggravated battery with a firearm, and aggravated assault with a firearm. And that's what the warrant, the judge signed the warrant, that there was a probable cause to arrest on May the 2nd.
On recall.
So we're just,
He was
here to
just picked up on the warrant,
Yes.
is what it was.
Yes, so we're just here to
he's just
determine the
here on
bond.
warrant that a circuit judge already signed
Correct.
for no bond on count 1. That's what I'm looking at the warrant.
It was signed that he would be picked up, but I don't believe his bond has been determined. So we just need to determine his bond.
Well,
And
proof evident presumption, great.
correct.
I'm going to order no bond, and he can go before his trial judge, and they can address all the issues then. Sir, I'm ordering a no bond. You'll go before, that's just for today. You'll go before your trial judge, and you can argue your issues on bond at that point in time, okay?
And Judge, that be for counts 2 and 3 as well?
That will be for counts 2 and 3 as well.
Oh, wait,
What?
wait, so you're gonna hold him no bond for count 1, 15,000,
You-
change it? Leave it at
Those are,
They're all,
Not-
these charges are all related.
yes, but they're not punishable by life felony, so it's up to your honor.
Okay, well then, it'll be 15,000 for count 2 and 15,000 for count 3.
Okay.
But the no bond for proof positive, proof
For
evident
count 1.
presumption, great, will cover because.
Okay, thank
All
you.
right, we're concluded, sir. Thank you.
So when do I come back to court?
That, they'll give you a date, sir, when they have it. He doesn't have a date right now. They'll let him know. All right, Miguel Antonio Lorenzo.
President Maine, Your Honor.
All right, Mr. Lorenzo, you've been charged with carrying concealed firearm. right. I do find probable cause, state.
Judge, he has no priors in Broward.
Alright. Sir, how long have you been living in Broward County?
For about 4 days.
4 days. Where were you before
Yes.
4 days ago?
I was in Orlando because I'm homeless.
You're homeless, okay. Are you staying at any shelter or anything now?
No, ma'am. I was living in my car.
Okay. Where's the car now?
My friend. Where's the car? The car is parked where I got arrested at.
All right. Mr. Dessler, you have any position on this as far as?
Your Honor, I would ask for him to be released on a pretrial because even if he is homeless and pretrial doesn't have an address, if he misses court, there is basically punishment in place that a warrant would be served on him. And so even though he doesn't have an address, there is a mechanism in place to get him to court if he decides not to show up. So I would ask for him to be on pretrial release.
State? Do you have an issue with that?
Judge, I'll leave it up to Your Honor's discretion.
Okay, I'm gonna do pretrial release for
For free.
for the charge. Just make sure, sir, that you show up, okay? Okay.
I will, yes, thank you.
ROR pretrial. Standard pretrial.
Thank you, Your Honor.
All
Yes,
right.
thank you.
Rayburn Hawthorne.
Excuse me, Your Honor, can you just state no weapons?
President Maine,
yes,
Your Honor.
Okay, whoa, back.
Wait. Yes, Your Honor.
Okay, just make sure no weapons or firearms, okay? So he can't possess any of that.
He understands, Your Honor.
Okay. All right, now, Mr. Hawthorne.
President, Your Honor.
All right, you've been charged with trespass, failed to leave property upon order by the owner, and an out-of-county hold for a felony. All right. All right, I do find probable cause. State?
Judge, he has just one misdemeanor from 10 years ago in the county. Resisting arrest.
Okay. We have
Your Honor.
But we have the out-of-county.
But we have the out-of-county, which it looks like he has a $20,000 bond amount, so he has to go back to that county.
All right.
Your Honor, I would just ask for ROR on the trespass count 1, what's here in Broward, just so he could be extradited to whatever county the felony's in. I'm not sure what county it's in.
Pinellas County.
Pinellas County is what we're talking
So I would ask for
Mr.
him to be,
Dessler.
I would ask for him to be ROR'd on the trespass so he could be brought to Pinellas and deal with that case there, as that's a felony, and this is a misdemeanor.
Okay, I'm gonna, as I said, found probable cause. I'm gonna order ROR on count 1, so that will give the Pinellas County the ability to get him up there and deal with the felony charge up there.
Thank you, Your Honor.
Okay. Terry Leroy Johnson.
Good morning, ma'am. How you doing?
No problem, Your Honor.
North
problem.
Broward. Okay. Good morning, Mr. Johnson.
Good morning, ma'am. God bless you.
Pardon me?
I think he said, God bless you.
Oh, thank you. You are charged with failure to comply with registration law in both count 1 and count 2. All right.
May I speak, Your Honor?
It would be best, sir, if you don't. This is this is just to determine probable cause. You are entitled to your Fifth Amendment rights. Anything you say can and will be used against you. This is not your trial or for this court to determine
No, I'm
your
just saying
innocence
about
or guilt.
my health. No, ma'am, I'm just saying about my health. I go to physical therapy Monday, Wednesday, and Friday due to the stroke I just had. That's why I'm not able to. This place is kind of hard on me right now, ma'am. If I could be allowed to go.
Okay, hang on just a second.
Mr. Johnson, I'm going to address the court regarding your health situation on your behalf, okay?
Okay, let the public defender speak on your behalf. There's an attorney
Yes,
in
ma'am.
court here who speak on your behalf about the circumstances on your being detained or not, okay?
Yes, ma'am.
All
Yes,
right.
ma'am.
Okay, so hang on, let me just get to. All right. I am finding probable cause on the charges. Now, Counselor, you wish to address the issue of bond?
Yes, Judge. Mr. Johnson is a lifelong resident of Broward County. He tells me that on December 2nd, 2016, he suffered a stroke. And due to that, he's filed for disability, but has not yet received it. He does have 2 grown children, and he does live with that more. So he does have someone that he can stay with and live with, Your Honor. So due to the effects of him having the stroke, we would ask the court to take that into consideration as far as setting the bond for Mr. Johnson. Perhaps maybe pre-trial release with a GPS monitoring or something like that.
Okay.
State would be objecting, Judge.
Pardon me?
The state would object.
And the basis?
Judge, he has a lengthy history. It appears from the PC that he left his halfway house group home in August of last year and wasn't seen again, and he failed to follow the terms of his sex offender registration, which is a serious concern.
Excuse me, ma'am. My attorney didn't mention this.
Don't address the allegations, Mr. Johnson, okay?
No, I'm not going to address the allegation. All I'm saying is I was on probation. May I'm allowed to say that, sir? And I graduated from that program, and they took me off probation. A judge took me off probation as an early termination.
Mr. Johnson, you're addressing the allegations, sir.
Oh, I'm sorry.
Okay. All right.
Just heard it. You know, and paying.
How often are you attending physical therapy, sir?
Monday, Wednesday, Friday.
Okay, and how do you get there?
Logistic. My Medicaid logistic transport.
Are you presently
They
living
take
with
me.
you? He's going to be, Counselor, is he going to be living with his son?
Miss Moore, right?
Okay, so he's living with family?
Yeah.
Yes.
That's my caretaker.
Okay, so you have, okay. All right, I'm going to,
I do whatever you need me to do, Your Honor.
all right. Now, he's applied for disability, you said, but he's not receiving?
Yes, ma'am.
Okay, all right.
I think that people were perhaps on like the GPS monitoring that would also.
I'm in the disability determination
Please, sir,
department right now.
please, sir.
I'm
right
sorry,
now,
ma'am.
let your
I'm
counsel,
sorry.
let the public defender's office speak.
That also may alleviate the state's concerns as far as his whereabouts. It would be allowed, his
Right.
location would be allowed to be tracked if he were on GPS.
Right, okay. Well, that's what I'm gonna order, that he be released and put on GPS monitor. I think that will alleviate the concerns of the state. Pardon me?
Any bond, Your Honor?
No. Standard,
GPS, no bond. I mean, RR, so technically,
Yeah.
GPS and RR on the charges, right?
yes.
Okay. Thank you.
Okay, sir, you're gonna be ROR'd with a GPS monitor, so you'll be able to get to and from your appointments and everything, but you need to make sure you show up for court.
I will,
All
ma'am.
right,
But
and then you'll address everything at that time. All right, Wendy Prevost, where is she?
Monday, right?
He's present in Maine, Your Honor. He has a private attorney, Michael Cohen.
Okay, have we contacted Mr. Cohen? Pardon? Have we called him?
Same thing.
But should you know about the phone?
Can we, okay. Can somebody?
And Your Honor,
I can find his
just,
number.
just as a friend of the court, I would ask if Mr. Prevail can access his property so he can get his phone, because he hasn't been able to call anybody because he doesn't have the phone numbers, but he does have his phone and property. So I would ask as a friend of the court if Your Honor would sign an order so he can get his phone.
Oh, I have no problem doing that, Mr. Dessler. I'd like to be able to, does he have his attorney's phone number that we can at least call him and let him know that he's in court today?
His family has the number, so if Your Honor maybe wants to reset this for tomorrow, and if then at that point Mr. Prevail can access his phone.
That's exactly what we're going to do. We're going to reset this for tomorrow. I'll be here, and we can then see what we can do, and your attorney will be able to present for you. Okay. Levant.
President Maine, Your Honor.
All right, Mr. Levant. You were arrested on a violation of probation on a felony charge. So, you have a hearing scheduled for May 9th at 8:45. And that this is on the violation is that's the warrant that he was picked up on? Was the violation? Right. Okay. So you'll address your issues on bond with the trial judge at that time.
Thank you, Your Honor.
All right. Chad Darren Sanford.
President Maine, Your Honor.
Good morning. All right,
morning,
Mr.
Your Honor.
Sanford, you're currently charged with robbery, no firearm or weapon, grand theft auto, and a violation of pretrial release condition. All right.
False affidavit, I just have the, violation of pretrial release.
It was a warrant. So the arrest warrant was signed
April 14, 2017.
Correct, for strong arm robbery, grand theft auto, and violating the dating violence order.
So
that's already done.
Right. So based on the warrant for arrest, that is the probable cause for this. So what I'm finding based on the warrant that there is probable cause. I am State, do you have any recommendations or anything to add?
Judge, he has. Sorry, I just lost my spot. He has a number of priors. The state would be requesting that Your Honor go with the suggested bonds of $15,000, $10,000, and $10,000.
Okay. Mr. Sanford.
Yes, ma'am.
Okay. How long have you lived in Broward?
All my life.
Are you working?
Yes, I have 2 jobs and I take care of my grandma. She can't walk, and I feed and I bathe and stuff when I come from work and stuff.
And Your Honor, I don't have a copy of the warrant. I'm just, for clarification, was it an out of custody warrant that was signed?
State? Was it not a custody warrant?
Yes.
Yeah.
Yes.
Your Honor, Mr. Sanford can't afford the bond as they're currently set. I'm also unclear on the violation of pretrial conditions because I don't know I don't believe he was on pretrial because he hasn't been in front of a judge yet, and that's just confusing us. If this was an out of custody warrant, how he could have been on pretrial if he hasn't been in front of a judge.
Good question.
And Judge, the only information I have is the warrant that was signed by another judge.
Well, now we both have as much information as we have.
Judge, in the warrant it says I'll look up the statute. It's dating violence.
That's what it says.
Right.
But I don't know what the violation was. There's nothing in here. So, all right. What do you said you work 2 jobs, sir?
Yeah, BG demolition, and I cut grass too.
All right. So
And I
what you
pay
in?
child
What
support.
you? Pardon me?
He also pays child support.
All right.
Judge, I don't know that it's pretrial release. The warrant says dating violence. It could be violation of an injunction against repeat violence and dating violence.
Your Honor, I think what it is we don't have that statute, 784.046. We only have the statute with the 15 at the end, so that's probably how they broke it.
Right. But 784.046, which is what's on the warrant, also includes violation of an injunction for protection from dating violence.
784 is the dating violence.
Right,
I'm well
so-
familiar with the statute.
So that could be what it
I just want to
is.
know the violation could be a number of things.
Correct, and on the warrant, it just says 784.046.
Right, but it doesn't say what type of violation.
No, it just says
All
dating
right.
violence.
All right, here's what I'm going to do. I'm going to order a... Have these bonds already been set, though? By Judge Lynn? By Judge Lynn, she retired. Okay. The warrant for arrest was signed by this, when was this signed?
April 14th, but I can see who signed it.
Of what year?
This year.
I don't think so.
That's what the warrant says, 14th
It says it
April.
was signed by Judge Thomas Lynch.
Correct.
Are we talking, is he going now by Thomas, not Michael Thomas?
I don't know, Judge.
I thought it was Michael, I thought Judge Lynch was going by Michael Lynch. All right, just wanted to make sure it was.
A real judge?
Okay, so, no, the correct.
I know what you mean.
Yeah, okay. Now, here's my question then, is that the bonds, were those already set?
Judge, I'm not sure. In the
'Cause they're
warrant,
listed on the bond.
it's not listed in the warrant, but the state would request those bonds.
It actually
These charges are very
was
serious.
listed on my warrant
Of 15, 10, and 10?
of April 14th of 2017, it appears. All right, so.
Oh, yes, you know what, Judge, correct. It says bond is fixed at
Yeah,
15,000
all right, so
for one
the
and.
bond's already been fixed on the
Correct.
warrant by
I'm
the
sorry.
trial judge. So I'm not gonna disrupt that. You'll address those issues with the trial judge. I don't have that authority to disrupt what the trial judge has already set.
Thank you, Judge. I apologize for that.
That's okay.
Mix up.
Okay?
Thank you, Your Honor.
All right. Nicholas David Escurdo. He bonded, all right. Alan Michael Caldwell.
President Maine, Your Honor.
Okay, Mr. Caldwell. You are charged with grand theft, and there's also an out-of-county hold for a civil case.
For who?
I don't know what county we found out. Oh, looks like Lee
Lee County.
County. Yeah, looks like Lee County.
Your Honor, the bond for council was corrected, it should be $392 instead of no bond.
392.
Yeah.
Thank you.
For where? Which one?
The out of county.
Oh, where it says 0, it should be 392? Interesting number. Alright, let me see. Okay, on count 1, I find probable cause. State, do you have anything to add?
No, Judge. His charges, he has a drug charge from 2015, and which he received 3 years probation, so he should currently be on probation. Don't know if he still is.
Oh.
It looks like he's not, not because it's not listed as a violation of probation. So.
Okay. All right. Sir, how long have you been a resident of Broward County?
Been arrested?
A resident.
Oh, all my life.
Okay. And do you have a job?
Actually, I do. I just got hired yesterday at the Fresh Squeeze in Dania Beach. I start Monday at 7:30. It's crazy. I just got.
All right. Well, I'm going to order a $500 bond on count 1. Can he really bond on the 392? They said it.
That Lee County said it.
They set his bond.
So.
All right, now I'm gonna go. Hey, Lee County gave you a deal. You got a $392, right?
Yes.
$392 bond in Lee County. That one I have no authority to adjust. That's what they set. But those are your bonds, sir.
And 1,000 for count 1?
No, count 1, 500.
Okay, I'm sorry, I misheard.
Okay, count 1, bond 500. Count 2, well, 2 is the out of county hold that Lee County says you can bond out of that for $392. $392.00.
Thank you.
Cash.
Right.
She loaded. What?
Okay.
What?
You know, the corrected book that you have to get this.
All right, we're concluded. He's telling him he's got the deal of the century. So he go back to the town. Okay, Charlie Jackson Tiger the Third.
President Maine, Your Honor.
Okay. Mr. Is it Tiger or Tiger?
Tiger.
Tiger, okay. Mr. Tiger, you were picked up on a violation of probation of a felony, and you have a status, you have a hearing before your trial judge on May 9th at 9 a.m. So I have no authority to disrupt that, sir.
Okay. Thank you, Your Honor.
Okay, so you'll
Thank
see
you.
your trial judge on May 9th.
All right. Thank you.
Have a good day. Preston Laurent Sabat.
President Maine, Your Honor.
Okay. Mr. Sabat, you are charged with possession of a forged driver's license or ID and driving with a suspended or revoked license. Okay, can I read half a second and then... All right. Counselor?
Your Honor, based on the probable cause affidavit, I don't see any evidence that he was in possession of the weapon with a suspended or revoked license to start with the first account too.
State?
Judge, I would concur.
All right, so.
I don't have a citation.
Probably because what he had was a forged license.
Correct.
So therefore, if it's forged or fake, how can it be suspended?
Correct,
I think
unless
that's your premise, right?
unless they're saying that his license was suspended, so he got a fake one, but there's no facts to support
There's no
that.
facts to support that.
Correct.
So I find no probable cause for count 2. I do find probable cause for count 1. Okay, on the issue of bond, Mr. Dessler, you have anything to add?
Your Honor, I would just ask for the convenience bond to be imposed of $1,000.
All right.
He has no priors in Broward, Judge.
All right, I'm ordering a bond of $1,000 on count 1. Have a good day.
Thank you, Your Honor.
Thank you.
All right, Casey Meyer.
Casey Meyer?
President Maine, Your Honor, he has a private attorney, Michael Weinstein.
Has Mr. Weinstein been contacted?
Yes.
Pardon me?
Yes, ma'am.
Okay.
I'm working on trying to take a polygraph.
All right, well, he's not available now. Will he make himself available for tomorrow if we put this on recall?
Yeah, that's gonna work.
All right. You're charged, sir, with aggravated assault with a deadly weapon without intent.
And Judge, just for the record, a no bond capias was already issued by Judge Robinson on Friday for his other open case, which is an aggravated battery with a deadly weapon.
Oh, okay.
So on that case, he's going to be held no bond regardless.
Okay, sir, in addition to your new charge of aggravated assault with deadly weapon, you have or is that the same charge?
No, the victim on the new case, ag assault with a deadly weapon, is a friend of the victim on the first case, which is aggravated battery with a deadly weapon.
But we're only here, mine shows only.
Correct, but I just wanted to make the defendant aware that he's being held on there's a no bond capias issued on a different case number. It was issued just yesterday by Judge Robinson.
Okay.
So I just wanted the court to be aware.
Sir,
He's not
given the
getting it.
fact that you have 2 no bond warrants right now, no bonds on you, I'm not going to disrupt what your trial judge is already issued. I have no authority to do that. So when's he going back before the judge?
Judge, I don't think he has a new date yet because he was a no-show.
Okay. Well, sir, you're already on a no bond from your trial judges, so
I'm sorry, not Robinson, Rothschild. I'm sorry.
Judge Rothschild.
Yes.
Okay, so that's what I thought.
No bond capias on case 16-15133.
No, this is on ag assault 17
Correct.
4936. That's all I have before me. So you're saying there's
I just wanted to make him aware that he
that-
has a no bond capias already issued that was issued yesterday.
Okay, sir, it appears on case number
16-15133 CF10A.
Okay, did you hear that case number, sir?
Yes.
Okay, well, it appears that case, not this case that you're before this court today on, but that case, Judge Rothschild?
Yes.
Issued a no bond warrant on that case yesterday. So your private attorney will hopefully, you'll let him know or he'll find out about that. But you'll address that with your trial judges, so I have no authority to address that. So you have a no bond warrant right now, sir. All right?
And then are we rolling this case to tomorrow?
We're not going to roll it to tomorrow because it's not going to change the warrant that Judge Rothschild issued.
So we are rolling it to tomorrow, we're not?
No, we're not rolling it to tomorrow because there's.
But it's a separate case.
The case on him now is Hope Magistrate.
Correct.
These are two separate cases.
They're two separate cases, and I know I'm probably confusing this. I started this. I know. I started this. But I wanted him to be aware and tell his lawyer that yesterday, less than 24 hours ago, another capias was already issued.
Okay,
So on
so-
this case, we still have to address it, but if you want to roll it to tomorrow so Mike Weinstein can come in,
Okay.
that's fine.
Fine. Well,
Sorry,
we're gonna-
I like was getting. I was addressing the other case. I just wanted him to know.
Too many teeth. Okay. All right, sir. The last, here's the clarification. We're going to reset this for tomorrow for your attorney, Mr.
Weinstein.
to be present for you tomorrow. We're going to put this back on the docket for tomorrow to address the new aggravated assault charge under case number 174936 CF 10A. At that time, then your attorney will address the other case, no bond warrant, but
with him.
We'll deal with that with your attorney present tomorrow. Okay?
Okay.
All right. That's all we can do. It's reset for tomorrow. Roberto Rivera.
President Maine, Your Honor.
All right.
After this guy, Your Honor, I need a favor.
All right. Mr. Rivera, you are charged with resisting an officer with obstruction without violence, and there are 2 out-of-county holds, 1 felony, 1 misdemeanor. All right. What is your name?
Jared Hawker.
Okay, Mr. Hawker, you stood up, so I gather you have something to say.
Yes, Your Honor. With regards to the charge, I don't see how Mr. Rivera resisted, opposed, or obstructed the officer. The officer simply asked Rivera what his name was, and although it appears that the name he gave him was correct, he didn't try to flee, didn't try to censor grace, or do anything of the sort. Did not stand in the officer's way whatsoever, Judge. We would ask that there's not probable cause for count 1, resisting obstructing without violence.
State.
I agree, Judge.
Okay, so I find no probable cause for count 1, but we still have the issue of the out-of-county hold in the felony and also on the misdemeanor. Now those you want to be heard on that too, Mr. Anybody?
No, Your Honor, they are out of county hold. I'm being told from Orange County.
Yes.
So if he's going to be no PC, he's going to be ROR'd on count 1. I expect he would probably get extradited to Orange County to deal with those cases.
Exactly.
I have nothing to add, Judge.
Pardon me?
I have nothing to add.
Okay, so since there's no PC on 1, he's going to be ROR'd with, and then they're going to be able to, it's in Orange County?
Yes.
Okay, so they will keep hold of him long enough for them to come and get him.
Thank you, Your Honor.
Tarval Dentuan where?
Present, Your Honor.
Okay, hang on just a second.
I need a favor, Your Honor, after this defendant took call back, Johnson Terry from North Broward.
Okay, all right, thank you for I apologize, I was supposed to do it at the last one. All right, Mr. Ware, you are charged with felony battery.
Thank you.
All right, I find probable cause, state?
Judge, Mr. Ware has a number of priors in Broward. He has cocaine charges from 2006 and 2007, and 2013. And he has recently pled out misdemeanor cases in March of this year.
Mr. Harcourt.
Yes, Your Honor, if I can be heard in regards to probable cause.
Okay.
Regarding the statute under which Mr. Ware is charged, there's no indication of a domestic relationship. The statute says that intentionally touching or striking and causing great bodily harm, permanent disability, or permanent disfigurement. There's no evidence in the probable cause affidavit that there was great bodily harm, permanent disability, or permanent disfigurement. The defendant's argument is that Mr. Ware there's no probable cause for the charges that Mr. Ware is facing, the charge of felony battery.
Okay, state, is this enhanced because of elder?
Of the age, correct.
Of the age,
It's a
that's what I
felony
thought.
battery.
It's elder abuse, correct?
Yes, it's felony battery, it should be felony battery person over the age of 65.
I saw the age listed in the PC.
Yes.
That's why, since they noted it in the PC as well as disabled, because they said he was in a wheelchair, that's where I thought the enhancement
Yes.
probably came in.
So I'm not sure why they used that specific subsection, but it is a felony battery of a person over the age of 65.
Okay.
Your Honor, I would
And
say-
it's,
Subsection he's charged, there would be no probable cause. Subsection he's charged of.
All right, well, state, I'll give you 48 hours to perfect if the issue is the subsection. I mean, the PC has, pardon me?
Your Honor, I would also add that the PC doesn't actually list the victim's age.
Yes,
It doesn't say how
does.
they identified the victim's age. It just says he's over 65, but I don't know the
Which-
date of birth,
but-
and I don't know exactly how they identified the date of birth.
being over the age of 65 is enough for PC to find PC for a felony battery on someone over the age of 65. They don't need to list his specific birth date just for PC. But I will take the 48 hours to get the statute changed in the PC affidavit to the correct felony
To the
battery statute.
correct subsection.
Correct.
All right, so 48 hours to correct. I'm going to ROR him while they're perfecting. Okay? Anything further we need on that? All right,
Thank you.
Thank you, Your Honor.
all right. Tavin, oh, no, hang on. So we got to do a call back, right?
North Broward, Your Honor, Johnson, Terry Johnson. Just want to state something for the record.
All
Your
right,
Honor.
let me just get. Oh, Mr. Johnson.
Your Honor, I asked.
Good morning again, Judge.
Okay, hang on.
Your Honor, this is pre-trial. I asked Mr. Johnson back because he was released on GPS monitor.
Yes.
Because of his charges, I wanted to let the client know, defendant know that he had, there's limitations regarding where he can live. And the address he gave is across the street from the park. He can't live anywhere near school.
Oh, because the registration
So,
is.
just want to let him know he's gonna stay in, since Your Honor ordered GPS until he has a valid address that where there's perimeters where he can be across the school or park.
Okay, sir, do you understand the situation right now?
Just want to let him know.
Ma'am, all I'm trying to say, Judge, is this. My social worker, she got in touch with my cousin Ann Johnson in Pompano right here, 27 on 7th Street, but I don't know the exact address until I go by there and get the address. And I said I'd take that with me Monday to see them.
But you can't, sir. See, here's the thing. In order to get the GPS and get everything done, we need to make sure the address that you're staying at is not gonna continue to cause the violation of your restrictions as to
Yes, ma'am.
where you can and can't reside. So
Yes, ma'am.
we can't release you while you're giving that you're not giving us an address where you're gonna be. So what I'd recommend is whoever it is where you're going to stay that isn't the present address you are located at, that you just have them give you the address. They will give, then you can provide it to pretrial. Then you can be released on the monitor. You can't go and
Yes,
get
ma'am.
see, do you understand?
Yes, ma'am.
It's like which came first, chicken or the egg, all right? What we're gonna do is you're gonna get the person who you're going to stay with, not at the address across from the park, that other location that you're telling pretrial. Just ask them to give you the address, all right?
I got a phone number. It's in my phone in my property.
Do you have access? Okay, Mr. Harcourt, do you need an order to get him? Okay, well, I'm gonna sign an order today, sir, so you have access to your property to get your cell phone to make that call. Is that what you need?
Yes, ma'am.
So that you can call and get the address where you're going to be going, not across from the park.
Yes, ma'am.
Okay, will that help in getting this expedited for you?
Yes, ma'am.
Okay, I'm gonna sign that order today to get you.
My other thing is, Judge. My other thing, I can't sleep here like another night. I'm hurting.
Okay, so the faster that you get on that phone to get the faster you get on that phone to get that address to pretrial, the faster you can be released.
All right, all I need to do is get my phone.
I don't know. Okay, great. Well, I'm signing that order now. All right.
Hey, Judge, if I get the address right now, when I get it, how can I get it to pretrial right now?
We will call you. We will
Today?
contact you.
Can you please make sure that
It's
it's
gonna be verified today, but we will call you. That's how we found out before, but we will contact you. Wherever you're located at North Broward, we will call that unit. We will contact you.
We're gonna do the best we can, sir, okay? It has to be obtained, and then they have to verify the location. That's how they found out the address you had wasn't gonna be suitable.
I know it's on 7th Street. I know it's 7th Street, but I don't know the house number.
I understand, sir, but they really do need an actual address, not just a whole street. All right?
Yes, ma'am.
Thank you, sir.
Thank you, Your Honor.
All right. Give me the order to sign.
PD's right there.
Okay. And PD, can you just make sure that that gets expedited so he can get his phone to get that address as soon as possible? I don't know how long it takes, but get that expedited.
You go on the property.
All right. Tevan Jamarcus Phillips.
Present, Your Honor.
Okay. Mr. Phillips. All right. You've been charged with expose count 1, expose count 2, expose count 3, count 4, lewd lascivious exhibition, count 5, lewd lascivious exhibition, and count 6 and 7, kidnapping. I do find probable cause on all counts. State?
Yes, Judge. Counts 6 and 7, that's the right numbers, yes, are punishable by life felonies. The state would argue that the probable cause affidavit is enough for proof evident presumption great, as litigated in Brackett v. State. So for counts 6 and 7, the state would be requesting that he be held no bond.
You know, defense would ask that the court not find count probable cause on count 6 or 7. It seems that Mr. Phillips approached the juveniles, you know, based on the probable cause affidavit to expose himself, but it, you know, doesn't seem that he was necessarily confining them or, you know, necessarily taking them anywhere in particular. So we would ask that the court not find probable cause on the charge of kidnapping. He wasn't certainly present, and it appears to be based on the probable cause affidavit, an outdoor location.
Judge, it doesn't matter in the kidnapping statute whether or not he's taking them to an outdoor or indoor location. The statute states that kidnapping is forcibly, by cruelty, or by threat, forcibly, secretly, or by threat, confining, abducting, or imprisoning another person against his or her will, without lawful authority, with the intent to do a following number of things. In subsection 2, it's with the intent to commit or facilitate the commission of a felony. The felony, the state would argue, are all the felonies he's already trying to and has committed, lewd and lascivious, and it states very clearly in the PC affidavit, he grabbed the victim by the arm while still holding onto her juvenile daughter and pulled them both from the front yard into the rear gate of their property. He continued to pull them until he made it to the entrance of the doorway when he was startled by another person. The fact that he drags them from the front yard to the backyard because they were outside doesn't make it not a kidnapping. He doesn't have to take them into a house or into a car. He has to take them somewhere forcibly against their will.
I'm finding there is, under the statute, probable cause for 6 and 7. And I'm finding probable cause for counts 1 through 5.
Your Honor, sorry, I want to object to counts 4 and 5 in particular. The charge is exhibition to a victim less than 16 years old. There is no indication in the PC of those victims' ages. It does not say who identified them as a juvenile, if it was the officer, if it was the mother, but it certainly does not mention that they're under the age of 16. A 17-year-old could be a juvenile, Your Honor. I object to PC being found on those 2 counts.
On 4 and 5?
Correct, Your Honor.
Okay, well, I'm
Judge,
going to give...
Oh, I was just going to say, he did expose his sex organs to...
It doesn't have an age, it's what they're...
At a daycare, but...
Well, the problem... I'm going to give the state 48 hours to perfect
on 4 and 5.
4 and 5. I'm going to order on counts 1, $100 bond, on count 2, $100 bond, on count 3, $100 bond. On counts 6 and 7, I am finding proof evident presumption great. So there's no bond, and the factual issues regarding this can be argued to the trial judge at the time. Given that, the state will be has 48 hours to perfect 4 and 5, so I'm not ordering an additional bond on those.
Your Honor,
I didn't pull up.
Your Honor, when it comes to count 6 and 7, the no bond holds, I understand that you're finding proof evident, presumption great. I'm objecting to that, Your Honor, and if I just may lay a record, I would say it's the state's burden to make that, to proffer the evidence to prove that. All I have in Maine is the PC from the officer. I don't know if you guys have access to other documentation. I would say, though, that the PC does not rise to the level of proof evident or presumption great, just because it never actually lists what witness says what or what witness makes what allegation. It's unclear to me. There are no signed affidavits that we've been provided with. And for proof evident, presumption great, that is a very high burden. It's actually even beyond a reasonable doubt. And I don't believe the state has proven that burden to the extent to make that finding. And because I don't believe that finding should be made, that he cannot be held no bond on those 2 counts, Your Honor.
May I briefly respond, Judge?
Briefly, because this is not an Arthur hearing.
Correct.
Nor is it appropriate for an evidentiary
Correct.
Arthur hearing, counselors. So,
Briefly,
if that's
for the
what
record.
you're looking for, that level, Mr. Dessler, that is for the trial court for you to argue that there. This is the short-term issue that we address. So state wants to just reply to your
Just for the record,
assertion.
Judge, and I understand your position. Proof evident presumption great is not a higher standard than beyond a reasonable doubt. However, regardless, Brackett v. State, which is a 4th District Court of Appeals case, number 4D00-3061, clearly states that the state may properly rely on affidavits at a bond hearing to show that the proof of a defendant's guilt is evident or the presumption is great. It's very clear from the case law, so.
It's not an evidentiary it's
Correct.
not a full-blown evidentiary Arthur hearing. That is the appropriate venue for that hearing, Mr. Dessler, as you're well aware, is the trial court. So I'm sure they look forward to hearing all of your legal arguments at that time. Have a good day. Thank you.
I understand, Your Honor.
It's not related to a big argument, but, Mr. Phillips, I would ask this court to sign an order to allow him to get any necessary treatment or anything in relation to, any potential mental health issues. Mental health evaluation.
Oh, you're asking for a mental health that I don't think.
Well, I'm just not sure if defense counsel's asking that he be evaluated or that in case they want to evaluate him, they're allowed to. I don't think they're going to evaluate him if you don't ask and sign an order saying he needs to be evaluated.
Right, so we're asking for an evaluation if any treatment is necessary.
Okay, so basically you want an order to evaluate to see if he needs treatment.
Yes, yes.
All right, I'll sign that order.
Thank you, Judge.
All right. Brandon Oberg.
President Maine, Your Honor.
All right. Mr. Oberg, you're charged with aggravated assault with a deadly weapon without intent. I find probable cause. State?
Judge, he has no Broward priors. The state would be requesting a $1,500 bond.
Mr. Dassler?
Your Honor, Mr. Oberg's lived in Broward for 3 years. He lives in Fort Lauderdale. He lives with his wife and his 5-year-old son. Both his wife and himself work to support the son. The issue is if Mr. Oberg is in custody, the wife isn't able to work because she has to take care of the 5-year-old son. Mr. Oberg does have a job. He sells shoes. He makes about $1,000 a month. And I didn't hear if the state said he had any priors. I do not believe he does.
Not in Broward.
There's, pardon me? I'm sorry.
Your Honor, I apologize. These are only in California, and I'm looking at his history real quick to see the dispositions of the. You want to know his convictions, Your Honor, or the I'm starting backwards. 2005 is mostly drug-related. VOP in 2005, March 2005, driver license suspended. Failure to appear in 2005, and warrant was issued. 2013, possession of cannabis. Disposition unknown. That was a felony charge. It's all in California, Your Honor.
Okay, but nothing since after 2013.
No, nothing after 2015. Your
2015. What was
Honor.
2015?
Yes, 2015. I apologize. March 2015 was a violation of probation. It was revoked. Driver license suspended.
In where?
In California. I
Okay.
apologize.
Mr. Dessler?
Yes, Your Honor.
If he's got some sort of charge in violation in 2015 in California, and you tell me, did I hear correctly, that he's been a resident of here for 3 years?
He's lived here for 3 years, Your Honor.
Do the math for me, Mr. Dessler.
Because I need. You know.
He moved here and he was in the process of moving, and he says he moved here while he was still on probation in California, and they were monitoring him, and he's lived here for 3 years.
All right, well, so he has a stable address and a job?
Correct. Yes, Your Honor.
Okay. The victim's not his wife, right?
No, Your Honor.
Okay, I just wanted to make sure. All right, I'm going to order a $500 bond. And no contact with the victim of any kind, and no weapons. No
Thank
knives,
you, Your
no
Honor.
guns, no anything. Okay?
Okay, I got it. Appreciate it.
Alright.
Thank you.
Alrighty, thank you.
I got received a call from North Broward. They're saying that, Alliance Williams is having, some potential issues with medication. They asked if you could call that case first. It's one of the last cases after.
Okay, let me. Lioness Clifford Williams? Here we go, let's go.
No problem, Your Honor. Thank you.
Got it. Mr.
afternoon.
Williams.
Good afternoon.
Okay. All right. You are charged with driving while license suspended, avoiding a traffic device, and there's three outstandings writ of arrest.
They're child support.
They're child support. When I say writ rather than warrant, I'm familiar with the outstanding writs for child support. Those are purge writs?
Yes.
Okay. Yeah, then. Yeah, they're... All right. So...
So, Your Honor,
Okay, sir, here's the thing. I'm going to tell you. This is just a probable cause hearing, just to determine if there's probable cause for the arrest. This is not the trial. This is not the time to determine guilt or innocence. Don't
No, I
tell
wasn't
me
even
any
going
of
to
the
mention
facts of your case. All right?
no, I want to talk about the case at all. I just
Okay.
come out of hospital yesterday from a heart surgery.
Okay.
And they got me here. They won't feed me with medication. I don't want to die here. I need to be home where I got a nurse that comes see me every day. So I need to be home. I can't be here. I just got out of the hospital yesterday.
Okay, well, is there anybody who can get your like the nurse, or can you let the jail know so the nurse can get your medication to the jail?
I asked them. I asked them already. They're like, there's nothing they can do about it. That's what they're telling me. I don't want to die here.
There's something they can do, sir, because I'm sure they'll get you your medication. Hold
Yes,
on, sir, please give me an opportunity to.
Yes, ma'am.
All right,
Yes, ma'am.
thank you. Okay, I do find probable cause on count 1 and 2 as to the driving while license suspended and the disobeyance of the traffic device. Here's the situation, sir. Was there something else you wanted to say, Mr. Harcourt? I thought you were trying to stand up. Okay. All right. Here's the situation, sir. Even if, and I can order a bond on count 1 and count 2, the issue is you have 3 writs for child support purges. Those.
Yes, I could probably come up with that. I probably could come up with that, but the bond for the
okay,
the other one I can't.
Okay, well,
because I won't be able to get out.
Okay, hold on, sir. State, do you have a position on count 1 and 2?
No, Judge. I don't see his history in here, so no. I'll leave it up to
Well,
Robert's
I mean,
discretion.
count 1 is habitual, so.
No, I understand that,
whatever
so
it is,
I
it
see
was
that it is what it
habitual.
is, the 750, so I'll leave it up to Your Honor's discretion.
All right. All right, sir. I'm going to order ROR on count 1
Yes.
and ROR on count 2.
Yes.
What? Oh, good, so it has nothing, so that has nothing, so forget there's no bond issue on count 2 because it's a traffic infraction. All right, so I'm doing ROR on count 1. Here's the situation, sir. If you want to be released, you are going to have to pay the purges on
Yes.
3, 4, and 5 because this court has no authority to supersede those. So you
Yes,
owe
I understand.
$170 is the
Yes.
purge on one of them. 500 is the purge on the second, and hang on, I'm trying to read that.
836 on the other one, right?
876.
876.
876.
876. So you will need to pay those
Yes.
in full before they will release you ROR on the other bond, on the other
Yes, I
counts,
understand.
okay?
I understand that. That was a
Okay.
great help. That's what I
So
needed. I just needed
essentially,
that.
right now, sir, the key's in your hand on
All
how
right, I really
fast you get
appreciate
out. All right?
All right, thank you.
Have
You have
a
a great
good
day.
day,
Thanks.
sir.
You also too, man. Thanks.
Let me know. That's what my experience is. All right. What we back to? Joshua Scott Newman.
President Maine, Your Honor.
Okay. Mr. Newman, you have been, okay, you're currently in custody because of 3 violations of probation on felony counts. So, because of that, your trial judge has already, those are no bond. I don't have authority to interfere with those. You have a hearing before your felony judge on May 9th at 9 a.m. And at that time, you can address the issues of bonds then.
Thank you, Judge.
All right, have a good day. Bo Stephen Kinzer.
President Maine.
All right. Mr. Kinzer, you're charged with grand theft. I find probable cause. State?
Judge, he has DUI, DWI from 2003, drug charge from 2009, but he also has a theft from 2016 in this county. State would be requesting a $1,000 bond.
Respect to probable cause, I know there's different amounts at different times, so I don't know if it's more appropriate that he should be charged with a theft on multiple cases, I forget or what, but, look, each of the occasions, each time the amount was under $300.
So it's your, is it your position that essentially there should be 3 separate counts as opposed to one
It's supposed to be
big?
one count of grand theft, Your Honor, yes. There wasn't, there's no proof that it was all part of some common scheme. It was just, each individual occasion is less than $300.
State?
Judge, he stole a total of $445 from the same listed location. I don't know why it would have to be separated. I know that it occurred on separate dates, but it occurred from the same victim. If someone breaks into a house one night and then again the next night, I don't see why it would have to be 2 different cases and 2 different counts of theft. Although I've never thought about that before. I don't see why it would have to be a separate. I realize it's on separate dates, but it's the same victim.
It may be the same victim, but
I understand there are different occurrences.
The proof allegations of proving the elements would, because they're 2 separate
With each
dates,
separate time.
they would be each separate time that there would be
Correct.
different proof
And I understand
elements and
that.
possibly different witnesses for
Right.
each count.
And I understand
So
that.
I'm gonna give the state 48 hours to perfect, to take this PC with the allegations and make the necessary corrections if at all possible. All right, so on that note, because you're perfecting, I'm going to Okay, Mr. Dessler, do you have anything to say regarding?
Your Honor, Mr. Kinzer lives in Hollywood. He's lived in Broward County his whole life. He lives with roommates. He is a landscaper. He makes around $300 to $400 a week. If Your Honor is giving the state time to perfect, I would ask him to be released on his own recognizance in the meantime.
Okay, pardon me?
We're good, Your Honor. Thank you.
Okay, I'm gonna ROR him, and the state has 48 hours to perfect on the count. All right, Delroy Maxim.
Present, Your Honor.
Thank you, sir.
Mr. Maxim, you've been charged with possession of cannabis of 20 grams or less, with resisting officer without violence, and tampering with or fabricating physical evidence. All right, Mr. Harcourt, you're standing up. I assume you have something to say.
Yes, Your Honor. Let me be heard with regards to probable cause to count 3. And it's just alleged that in the probable cause affidavit that Mr. Maxim tossed a clear Ziploc bag away. I don't see how that would be tampered with, fabricated. He didn't try to alter the evidence in a way. Didn't try to destroy it. Didn't try to conceal it on the person. He just simply abandoned it. I don't believe there should be probable cause based on that count.
State?
Judge, he doesn't have to tamper with it or destroy it in order for it to, I mean, not tamper. He doesn't have to destroy it in order to tamper with the police recovering the evidence. He admitted post Miranda that he threw the bag away so that he wouldn't get caught with it, which is by definition tampering with physical evidence. He admitted it. He doesn't have to conceal it on his person or destroy it.
So the statute includes attempts to conceal, which I guess
I'll pull it up.
tossing would be an attempt to conceal.
Correct. Such as throwing it out of a car window, and in this case, throwing it
I
onto the
just
ground.
want to know
while
that
he's-
that's.
No, I'll pull it up just to make sure.
I would appreciate that.
Okay. Alter, destroy, conceal, or remove any record of with the purpose to impair its verity or ability in such proceeding or investigation. Conceal it with the intent and purpose to impair its availability in the proceeding of an investigation. It doesn't say conceal
tossing, I
on
think,
person, just conceal
Tossing at Mr. Harcourt, I think, is an attempt to have it not available
for investigation.
for investigation. So therefore, I am finding probable cause on that. I'm gonna order, pretrial on this, and given the,
He told pretrial that he lived in Jamaica, he's gonna be moving at the end of the month. He's still.
oh, hello, well,
He's
Miss-
fine, pretrial said he lived in Jamaica and he will be moving at the end of the month, so I don't know if that's true.
he's got pending charges. How's he moving?
That's what he told
Miss,
pretrial.
Mr. Dessler?
Yes, Your Honor. Mr. Maxim, he is from Jamaica. He's been living in Fort Lauderdale since December. He's a DJ. He makes about $70 to $80 for each performance that he partakes in. I would ask for the convenience bond to be kept on count 3.
We're not at that stage, Mr. But the issue is I want to order pretrial, and he's saying he's not going to be here. And I'm curious of how he cannot be here when he has pending charges. Does he understand?
He understands. He could come back and forth, but he's been living here for.
No, he
Can't
cannot
leave the
leave the
country.
county while he has pending charge. I'm not going to authorize him to leave the country while he has
What-
pending charges. Is that what his
I'm not
understanding
asking that
was?
Your Honor would. Sometimes some of the other judges do. I don't know who his judge is. But he understands in the meantime he can't leave. Eventually he might be in front of a judge who does allow him to travel. Sometimes some judges do. I'm not asking you to allow it.
Oh, thank you for not asking me to allow that. All right, so pretrial, are you saying that if I put him on pretrial, then the trial judge wouldn't have the authority to give him?
Just FYI for Your Honor, your final the decision is up to you, Your Honor, but he just told us that he was going to move to Jamaica. That's why we didn't recommend him.
And Judge,
So he wasn't a candidate for pretrial.
Oh,
But you could
got
still
okay.
put him on pretrial. It's your discretion to put him on.
Okay.
just for the record, I would object to him being put on pretrial release. He has just admitted that he plans to leave the country, so the state would be requesting a bond.
We're going to do bond.
Okay, thank you.
Okay, and it appears Mr. Dessler understands we're going to do bond too, because he was saying the count 3, the $1,000 bond was going to be the bond. I'm also given the amount. This is appropriate for drug court. I want to refer this to drug court.
I think that should be okay, Judge. It's he has no
Less than?
Yeah, and he has no priors in Broward, so.
All right. So, Mr. Maxim?
Yes, ma'am.
Okay, I'm referring this case to drug court. You have $1,000 bond on count 3. Okay, on count 1 and count 2, no additional bond. And sir, I would tell you that until you get in front of the drug court judge,
Yes, ma'am.
don't be leaving the country.
No, ma'am, I won't do that, ma'am.
Okay? All right, as long as we're clear.
Judge, I'm sorry. I think, and again, this is my fault for not saying something earlier because I have a juvenile court brain, but I think that they should go to a regular judge first, then that judge can send them to drug court. For adult. Because he has one felony, which is tampering. So the drug charges are misdemeanors, and that's why I was thinking because juveniles and they go to drug court on felonies, and I have that brain, so that's why I didn't say anything. But because he has one felony charge, I think he has to go to a felony courtroom, and then that judge can send him.
All right, did you hear some of what was going on? What's going to happen is that because of count 3 is a felony, you'll be in front of the felony judge. At that time, your attorney can ask for it to be transferred to drug court. I don't have the authority because of the felony to have it sent to drug court.
Okay, ma'am.
From the here. Okay?
Yes, ma'am.
All right.
Yes, ma'am.
Thank you.
Thank you, Judge. I apologize for that.
All right. Paul Raymond Timmons. I'm sorry, what?
Yes, ma'am.
I didn't.
He says that he's here.
I'm present.
Okay. Thanks.
Oh, well, good news, Mr. Timmons. Your bond's been posted.
Oh, how
right? I'm glad I made your day, Mr. Timmons.
Yes, you did, ma'am.
All right, you can have a seat. I'm sure they'll process your paperwork and get you.
That's it.
For you.
Yes, ma'am.
And Your Honor, if we could go back to Mr. Delroy Maxim, if we could please just get an order for him to access his phone. He told me as he was walking away he needs access to his phone so he can call his family to post his bond.
Can we get an order on Mr. Maxim? Okay, your colleague in court, Mr. Dessler, is preparing that as we speak. The order to get it. I'll order that. Okay.
Thank you.
Not
Thank
a
you.
problem. Now. So. Okay. And last but not least, Luchin Moreau. We have an empty room.
You gotta tell her we got
Do we know where he is?
We don't know where those are, but we had two that were on recall from earlier, Your Honor.
Oh,
Mark
you have
Queen
recall.
Smith
Oh, sorry.
and Permito Garcia.
Okay, I'll go to North Broad. Okay, oh, wait a minute. Okay. No, we'll go to North Broad after we finish up here. Okay?
Yeah.
Okay, who do you have in front of you now, Mr. Dessler?
I have Mr. Garcia.
Okay,
present. He's on page
Primitivo-
13.
Gotcha. All right. So, Mr. Garcia, you are charged with false ID given to a law enforcement officer, and there's also an out of state hold felony for
New Jersey.
Let's see where it is. Hello.
It's a New Jersey, Judge.
It is New Jersey.
Yes.
Gotcha. All right, so as to the false ID given to Leo, All right, Mr. Dessler, I've read the probable cause affidavit.
I have no PC argument, Your Honor. The only thing I would ask is that on count one, that Mr. Garcia is ROR'd so he could be extradited to New Jersey to handle the much more serious case.
All right, I find PC for count one, and I will ROR him because New Jersey says they want their cash there. So he has to pay that, the bond they have set up in New Jersey has to be paid there. They have to have him in person. So I'm gonna ROR him on count one here so that he can be released to New Jersey so that he can handle the felony count up there. Okay?
Thank you, Your Honor.
Thank you.
And Your Honor, I also have on page 15, Mark Queen Smith.
Yes. All right. Mr. Smith.
Hi, Your Honor.
All right. You have been charged with grand theft, a false ID given to a law enforcement officer, resisting officer without violence, providing a false affidavit about driver's license, tag unsecured, obscured, or none, and then out-of-state hold for a felony.
Judge, it looks like he needs to be extradited to Iowa in that case.
Yes, okay, I was just looking at the other counts. I mean, I understand we're gonna send him off to the other state on the out-of-state hold. All right, Mr. Harcourt, do you have something, you're standing, so did you have something to add to this report?
With regards to count one, and even appear to be anything, about the Lexus as far as there being like a punch ignition, broken window or anything that would suggest that, he would know that the vehicle was stolen. So, we would ask this court not to find probable cause as far as count 1 of grand theft. As it relates to count 4, providing a false affidavit about commercial driver's license, I don't see anything in the probable cause affidavit that would support that he provided a false affidavit about a commercial driver's license. It would appear that he was asked about a driver's license, he was asked for the name, but the probable cause is absent as far as Mr. Smith being asked about a driver's license. We could ask this court not find probable cause for count 1 and count 4.
State?
Judge, I have no argument on count 4, the false affidavit about a commercial license. However, for count 1, it does state that the defendant exited the vehicle upon the officers turning on their emergency lights and fled, and the vehicle was reported stolen, and his actions, the state argues, are enough to find PC that he knew the vehicle was stolen.
And also with regards to count 1, it doesn't appear to be value listed in the probable cause affidavit as well.
State?
I mean, it was a car, so.
I know it was a car.
I don't know how,
but-
I don't know what year it was. It would be a felony grand theft, regardless of the amount. I mean, unless the car was worth, you know, less than $600, but.
Well, I understand, but.
And I know the
count
specific-
1 is listed
as
as
a second
over
degree.
20, over 20, under 100.
I understand.
So, I mean, I'll give the state 48 hours to perfect count 1 with an amount to identify what level grand theft we're talking. As to 2, 3, 5, I'm finding probable cause. I find no probable cause on count 4. And then we have the out of state. So in order to get him extradited to what state?
Iowa.
Iowa.
And I don't know if that would happen, while his cases are still pending, when he says pending charges in Florida.
Oh, because it's a felony.
Yes.
Because the state, are we gonna send him
I-
up there or deal with him down here first? It's a felony.
I understand that. For the grand theft charge?
Yes, yeah.
I think we should deal with that first, so we at least know if
Right,
there's
so
PC or
then
not.
I'm not gonna extradite him up there, we're gonna deal with.
Well, in 48 hours, correct?
Right.
Yes.
Okay.
I didn't know that you weren't gonna find PC, so that's why I was talking ahead of myself on the,
PC and everything else.
right, on the extradition. So, if we could wait till the 48 hours
Okay,
on the, count 6.
okay, so we're gonna hold him for the 48 hours, because there's we have the out-of-state hold anyway.
Correct.
Yeah, would the court consider signing an order allowing, photos to be taken of Mr. Smith?
Okay.
I don't know for what purpose, but.
For what purpose?
Yeah, I was informed by, my colleagues at the, main jail that there may have been some injuries related to Mr. Smith's, apprehension. So I was advised to ask this court for a photo order. I didn't personally speak to Mr. Smith, maybe Mr. Dessler.
Mr. Dessler? Do you hear what
Yes,
your
Your Honor.
colleague here in court has said?
Yes, that Mr. Smith has some injuries that he sustained when he was being apprehended by the officers. He has abrasions and cuts on his hands and his knees and his legs. So we're just asking for our office to be able to take photographs of those injuries.
All right, I'll enter that order. All right, so I'm gonna, all right, well, we've got the out-of-state hold. State has 48 hours to perfect. And I guess at that time, bond can be addressed then?
That's, yes. Yes.
Okay, great. So, that's it for, is there anything else, Mr. Dressler?
That is it, Your Honor, and we're done in Maine, so have a good day, Your Honor.
You too, have a good day. Will I see you tomorrow?
You'll see me tomorrow, Your
There
Honor,
you
bright
go.
and early.
All right. Gotta head over to North Broward. Hello. Do we have Lucien Moreau?
He's a medical reset, Your Honor.
He's a medical for another day?
Yes, please.
Okay, we will put him back for tomorrow?
Thank you.
Okay, great. Have a good day.
You have an even better one.
Thank you.